It's time for Twit This Week in Tech. I love this panel. Kathy Gellis is back. There are some Supreme Court decisions we got to talk about. Doc Rock is here from eCam. And Ryan Shrout, former host of This Week in Computer Hardware. Ryan's going to talk about the new Snapdragon X Elite. He's got all the benchmarks to explain it. We'll also talk about a big bust. Kathy says, how do you arrest 4,000 people in one day? The answers may surprise you. It's all coming up next on Twit.
Podcasts you love.
From people you trust.
This is Twit.
This is Twit, This Week in Tech, episode 986, recorded Sunday, June 30th, 2024. Our dope GPS. It's time for Twit This Week in Tech, the show where we talk about the week's tech news. This is the one show on the whole network where we have different people on every week, but that gives me a chance to kind of fine-tune the show to the news of the week. Our attorney at large, Counselor Kathy Gellis, is back because the Supreme Court was busy this week and finally answered a few questions we had.
They answered, one or two questions, but not as many as we needed them to answer.
Well, you could talk about that too, what's still pending. We also have Ryan Shrout here, our hardware guru. He's at signal65.com, but you may remember him from his time as host of This Week in Computer Hardware on our network. And of course, he was at Intel for a long time. And I am very curious on his take on the Copilot Plus PCs and Intel versus Snapdragon. I think you might have something to say about that. So it's great to see you again, Ryan.
Yeah, good to be here.
Welcome back. Is that a subway map of New York on the wall behind you?
It is a subway map of Disney World. It is all the transportation systems
That's awesome.
of Disney World.
That's awesome.
Mapped out in a subway format. Yeah. My daughter got it for me for Father's Day a couple years ago.
That is wonderful. That's great. It's good to see you, Ryan. Also with us, our good friend Doc Rock. He is Director of Strategic Partnerships at eCam, but also a YouTuber in his own right. You know he's a YouTuber because he's got a sign that says "On the Air" behind him. Hello, Doc.
Yes, I do. That was a gift from a viewer who wanted me to help her do some stuff for the studio, and then she sent it to me as a gift. And
that's
I love
a great thing. Oh, you need that.
I never turn it off though. I really wish I had a button to turn it on and off. So I can tell my neighbors to stop playing drums next door.
There you see.
But you know what it is.
See, you need like a bat signal. When you turn on the microphone, it goes in the sky. It says, "Doc is on the air. Stop drumming." That's what you need. We have a variety.
I'm going to buy a trombone to go after him.
We have a variety of on-the-air signs. My favorite one is one I got in the many years ago. Can you get it? It's not attached. And this I'm definitely taking with me. I've been taking with me from studio to studio. I got it in 1984 when I was a DJ for a new station called Clock FM. KLOK, and we were taking over the broadcast facilities of an old San Francisco rock station. I've been there since the 60s. Very famous San Francisco rock station. And I think the DJ played Don't Fear the Reaper and walked out the door. And I said, "Hey, man, don't you want your on-air sign?" He said, "Nah, you could keep it." So I did. But wait till you see it. It was from KSFX was the name of the station. It was a hippie station. And it says, not just on the air, it says right on the air.
Oh.
And it is kind of one of my favorite little pieces.
That wasn't a sign that was going to survive genres, was it?
I guess, yeah, because we went, Clock FM, the whole theory of Clock FM, the new radio station was, well, we even have a jingle. Build your own radio station. You always wanted to build your own radio station. Clock FM is you. And the whole idea, this was the worst idea ever, was we would start just playing Neil Diamond nonstop, 24/7. The idea is to get a lot of newspaper coverage because there were still newspapers. And then each day, the audience would call in and vote in a new artist.
Oh.
So in day 2, we had Neil Diamond and Barbra Streisand. And in day 3, we had Neil Diamond, Barbra Streisand, and the Captain and Tennille. And it went on I would say, downhill like that.
I'm not sure that sort of playlist could survive the DMCA. It made some rules about how much you could play from any particular album
that's
consecutively.
a good point. Yeah. Well, this was, I guess, in those days.
You were being creative.
Here's my sign.
Oh my gosh, the photography.
Isn't that great? It says right on the air in that classic hippie. Oh, look, it lights up. Look at that. So that will be my on the air sign. Isn't that great?
I bet that's an incandescent bulb on the inside too. LEDs.
We actually rehabbed it. We rehabbed it. It had some old funky stuff. In fact, it didn't have anything. I think I ripped it off the wall. It was just this plaque.
Oh, okay.
Yeah. So we
Man,
actually,
you got to trace that and turn it into a merch and throw it up.
Would you buy it? Okay.
Absolutely.
Always thinking.
Cool.
Always thinking. Isn't that cool? Right on the air. From KSFX San Francisco, 1984. I felt a little guilty going from Don't Fear the Reaper to Neil Diamond. Holly, holy.
Not really capitalizing on currently entrenched audience behaviors. Don't touch that dial.
And now, more Neil Diamond. 56 degrees in the city.
Don't touch that mouse button. Does not have the same flair.
Don't click.
I really am an old timer. That was, what is that, 40 years ago?
Well, so you took your slogan to heart with the go start your own radio station.
Yeah,
so you basically did.
I did.
Yeah.
And I'm pretty happy with the outcome.
Okay.
Get to talk to people like you. So, Kathy, what happened this week in the Supreme Court?
Well, we can start with what didn't happen, which is we are still waiting for them to decide the result in what we're referring to as the net choice cases. These are the cases where Florida tried to regulate social media, Texas tried to regulate social media. Their attempts eventually got put on hold via a variety of mechanisms, and that went up to the Supreme Court. The fundamental question there is whether some First Amendment doctrine that applies to newspapers applies to platforms. And that question is, there's a case called Miami Herald versus Tornillo, and that case says that the government cannot tell a newspaper what it can or cannot run on its pages. And that's an important thing, that the newspaper has editorial discretion.
Thing.
It's a good thing. That's from the 70s, where the Supreme Court said the First Amendment means that there's editorial discretion that belongs to the newspapers that the government can't interfere with. They get to decide what expression they carry.
I mean, it's authoritarian states like Hitler's Germany where they tell the newspaper what to publish.
Well, they were telling the newspaper in Florida back then because they wanted the newspapers to carry op-eds, that if they carried an editorial in favor of one political candidate, they had to do the other one.
Now, we had that. The FCC had the fair...
That was Spectrum. So that was different.
Because you're using the public's airwaves, you have an obligation.
That's why the First Amendment didn't necessarily say no to the fairness doctrine. Now, there may be other concerns with the fairness doctrine, and it's since gone away, but that's kind of how the government got to regulate over-the-air broadcasting, because it was using Spectrum, and that was the foothold that said the rules are different.
So Florida wanted the fairness doctrine for newspapers, which doesn't make any sense.
Right, and the First Amendment says no.
Right.
Now Florida and Texas and a variety of other states, including blue states, want to be able to pressure platforms in what speech they either facilitate or moderate away from their sites. And the big question in these cases before the Supreme Court is, can they do that? Or does the rule from Miami Herald versus Tornillo apply to online platforms, including social media platforms? I think the answer has to be yes. I think you run into real big problems if the answer is no, because you're going to get Governor DeSantis and Governor Abbott deciding how social media needs to be moderated. It did sound like from oral argument, which I had attended, that the judges seem to think that yes, there is a First Amendment right in platforms and how they choose to moderate their platforms, but we don't have a decision yet. So we don't know yes, but, no, but, we have no idea.
So this is the net choice cases.
Those are the net choice cases.
Net choice representing the tech industry.
It's Net Choice and CCIA together. They're two trade associations, and they sued Florida, they sued Texas. And
we have no decision.
And we have no decision.
Although both those laws are stayed right now.
They're both stayed right now.
So they're not in effect because the courts in both those states said, yeah, wait a minute.
Fortunately not, although technically that's not completely true. There's a couple of provisions that didn't get challenged or didn't get stayed, so technically a few are enforced, but by and large, the big bad stuff is not enforced.
But there were decisions this week
We
by
did
the
get one
Supreme
good
Court.
one. Yes.
You said there's one good one and one doozy.
At the time that I wrote the Textured Post, no, let me not say there's only one doozy that came out of the Supreme Court that day. That was Wednesday, I think I wrote. And on Wednesday, there was one good one and one doozy. The one that we're happy about is the case called Murthy versus Missouri. And this case actually got heard after the net choice cases. And this case was about a bunch of people who had been online users whose expression got moderated away or their accounts got deleted, being very unhappy that the platforms had moderated them away from their sites. So they sued, and then two states, Missouri and Louisiana, decided to also sue on their behalf and behalf of themselves and behalf of any other speakers who had been moderated away from social media. And they decided that that was a First Amendment violation because they thought what was happening, and technically there were conversations.
They thought the government was telling these platforms, take these guys down, as they did. Even Donald Trump said, oh, yeah, that was the government forcing Twitter to take me down on January 7th.
The social media platforms were having conversations with various government agencies about various topics, not necessarily the same
Chiefly
conversation. COVID, cybersecurity.
Attempts to influence the election. They saw some of the accounts on Twitter, for instance, seem to be run by the Russian military.
Yeah, there was intelligence that so a couple things. You had the CDC and the Surgeon General had some expertise in vaccines. And when the companies were developing their moderation policies to figure out, well, what kinds of vaccine discussion should we enable and what kind is dangerous, they were consulting with government experts to figure out what the policy should be. So they were having those conversations. They were having conversations in the cybersecurity realm because they wanted access to some of the intelligence of what is dangerous and how are we getting manipulated. So there were a variety of conversations the platforms were voluntarily having with the government. It ended up producing a very, very large and convoluted record because you had a number of plaintiffs, individual plaintiffs, state plaintiffs, suing a whole bunch of government agencies and involving multiple platforms who weren't even part of the litigation. And it turned into a big record. And because some of the correspondence from the government to the platforms was a little bit aggressive.
They were pushy.
Take
that down.
But some of the context of what they were being pushy about was not necessarily unreasonable. Like somebody was masquerading as a Biden account or something like that.
I don't think anybody would question the informational flow from, let's say, the FBI to Twitter. That account is run by the Russian military intelligence. Do with it as you please, but you deserve this information.
And the platforms may have been asking for that information.
I think they did want that information.
So they did. So this is the record. It's a very large, voluminous,
Nobody
not particularly
wants the
specific.
To be able to say you must take that down.
So there's a couple things. So the allegation is that by the government having talked to the platforms, it somehow forced the platforms into making decisions. I guess
That's
it wasn't
not
otherwise
unreasonable
supposed to
because it's the government, it's the FBI, it's the CIA. That has some clout.
Well, that was one of the plaintiff's arguments, but the response to that was not that. There was implicit in their argument that the government was basically saying moderate this or else, but they never substantiated what the or else is. And it also tended to presume too much from the record, including that the platforms were seeing the hackers as the threat, not the FBI.
Yeah.
They were seeing the FBI
They wanted the help.
They wanted the help. They weren't seeing them.
So what did the court say?
So the court basically said, kind of the way I'm telling the story is, your record is too much of a blob and you didn't draw enough of a line to say that those conversations to those platforms forced the platforms to do something they weren't independently going to exercise their own judgment to do. You haven't drawn a line between the thing you're complaining about and the federal government has either been the agent of anything that happened to you in the past, and especially not drawn a line to say that, and if not enjoined, they're going to keep doing it. They just said you have a kludgy record, you didn't plead very carefully, and therefore you don't have standing. You haven't shown an injury or a likelihood of injury, so you don't get to bring this complaint.
Justice Alito, who did in fact vote against the majority decision, in his dissent said that for some reason, internet platforms are more vulnerable to government pressure.
He's accidentally right about something, but I don't think he realizes he's right, and it's kind of irrelevant for this case.
He says Section 230 protects them, which we know it does. Mm-hmm. He brings up Section 230 and says this is the stick the government wields. Is, well, if you don't do what we say, we might take away your protection under Section 230.
Well, one of the reasons I brought up the net choice cases before getting into the one we have the decision about is we still don't have that answer of, does the First Amendment protect the editorial discretion of the platforms? We don't have an official decision that says yes, but there's a lot of language in this decision, including from Alito's dissent, that really sort of suggests the answer is yes, which I think bodes well. I think it's useful to lawyers. Even Alito indicates it, because prefacing the remarks that you just pointed to, he talks about, okay, the newspapers do have the editorial discretion, and then he comments that the platforms are more susceptible to government pressure. I think that's an interesting observation, but it really only matters if you think that that might be a problem because they actually have their own editorial discretion. And the points he raises about antitrust policy are quite valid. We've made the same points before, like with a lot of the antitrust reform that gets kicked around in Congress, particularly by Democrats.
Both sides of the case.
He's blundering into correct answers without realizing it. I wouldn't put too much credit, but it is a point that, for instance, Jim Jordan has raised with a lot of the Democrats' antitrust reform, that essentially if you tell Facebook, moderate this way or we're going to break you up as a trust, that looks like jawboning, because that looks like the or else and the type of government pressure that's forcing them to give up their editorial discretion and do it the government's way. In those instances, yes, I think there could potentially be a very real jawboning problem. But in terms of what these particular plaintiffs were alleging, and the garbage of their states alleging it on their behalf, no, there needed to be something specific to show that these people were hurt and that their getting kicked off these sites was not the choice of the sites that they could have made.
Sometimes what we see in a Supreme Court decision, we've actually seen it this week, is it's almost a procedural rejection. Like, well, you didn't have standing, or you didn't do it right, or in this case, it was a tar ball of accusations instead of a clear case. When the Supreme Court says that isn't really a very strong precedent, because it's really rejecting the case for procedural reasons, right? Was this one of those?
No, I think, well...
You think this is going to stand? Is this a precedent?
There's a fallacy, and we sometimes refer to it as coming in with the Erie doctrine, that some things are procedural and some things are substantive, and that we can tell the difference. And really, that's garbage, because the effects of procedure has huge substantive effects.
Sure.
So this is one where it was.
But if somebody made a good case, it wasn't a tarball of a bunch of stuff, would it be more likely to be approved?
Yeah, I mean, some people have raised the concern with this decision. I think it's a good decision, but the concern got raised that, well, did they just make it harder to bring a challenge in the event that true jawboning has actually happened? Right. And I don't think so. I think some of the more mature, and excuse me for saying so, the non-MAGA lawyering does tend to know how to draw a line between here's the injury and here's what happened and here's why it's this fault and here's why it's redressable. There's some standards for finding the standing that Justice Barrett was pointing to. I don't particularly know offhand why any of those were wrong, and she didn't change any of them. Right. So I think her point was she actually seemed to have done a pretty thorough look at the record and pointed out. She wrote the majority opinion. She looked at the record and actually pointed out, a lot of the conclusions that the Fifth Circuit and the District Court were making were some really facile conclusions based on a record that didn't support it.
Your piece in Tech Dirt describes the case as a DDoS attack against good jurisprudence.
Right.
That by hoping that there were enough plaintiffs, defendants, and platforms involved, the courts would just throw up their hands and say, well, if you all agree on that, this must be a good case.
They were searching for this looks bad, something bad must have happened, so therefore.
We support you.
Now, at the standing stage, you don't necessarily have to prove that the bad thing is. So the issue here is she's kind of deciding on the merits that they had no complaint.
Okay.
Standing really isn't supposed to determine the merits. Standing is really supposed to be, do you have an injury that makes you bringing this challenge to court? Do you have a right to pursue because that you have an injury where judicial process is going to potentially redress it?
That's to keep people who have no dog in the hunt from just
Right.
filing frivolous lawsuits.
And this matters because especially as you get all these government things, passing, just on the First Amendment front, for instance, there's a lot of garbage that's getting passed. And you need, a pretty wide latitude to have people able to challenge it. But this came up in the 303 Creative case where a lot of people are critical of it because the web site designer in particular had not actually been injured, and they're like, well, they just took her case because they really want to take the case.
Yeah.
But I don't think that's actually bad because particularly with these civil liberties type challenges, you want to be able to forestall the injury before it happens. We're not better off if you get censorship and then you complain about the harm that the censorship caused. Better off if this law is just careening into an unjust result, you challenge it and get it off the books so it can never hurt anybody. So we want standing to be liberally drawn, and some people are worried that this case might have narrowed how it could be drawn. I think good lawyering can probably handle it. I don't want to poo-poo all the concerns, but this was not well litigated. It was just throwing an awful lot at the wall, hoping it looked bad, and basically fishing for exactly what they got from exactly the courts that they got.
So on Wednesday, the Supreme Court said, no, the government did not force these social networks to take these posts down. Everything's fine. And they threw that one out. But that was Murthy versus Missouri.
Right. And chances are one of the upshots of that is they threw it out, but it's really been remanded. So it may not.
They sent it back down to the 5th?
I think so. I think it's just remanded. So they did talk about how one of the plaintiffs had a better argument. They didn't buy it
so
now.
They kind of separated out some of the
So there's probably going to be further.
Okay.
I mean, we'll see how it comes out. It doesn't give them a big leg up.
And the Fifth Circuit was the one that approved this in the first place.
The Fifth Circuit makes a lot of stuff up.
Yeah.
And I think what's interesting is our Supreme Court is crazy and not respectful of precedent and a variety of its own procedures, but it has no patience for the Fifth Circuit to do what it's doing. If anybody's going to be the kangaroo court, it's going to be the Supreme Court. So it's sort of interesting that they're shutting down this sort of renegade court and at the same time kind of pulling off the same hijinks themselves. But
you call the doozy Snyder versus U.S. What was Snyder all about?
What was Snyder all about? There's been too much this week.
I can tell you. Oh, wait a minute. It says error, file or directory not found. Good. Well, we don't have to worry about it anymore. The Supreme Court has apparently lost that case.
Snyder was the one where you can tip your government official after the fact.
Tip them?
Yeah,
gratuities. As opposed to bribe them?
Yes, you can't bribe your government official.
But you can give them money afterwards?
But you can give them a gratuity afterwards. And apparently that doesn't violate the anti-corruption statute.
Thank you so much for your excellent service. I'd like to just give you a boat. Do you mind? Thank you very much.
I think in the case in question, it was $15,000.
Whoa, that's a big tip.
Yeah, it's look, that was the first of the doozy, and then they kept issuing decisions other than the NetChoice one, and they got even doozier in many fronts. But.
And some have made the case that Chevron, which was really about the right of the administrative government, like the EPA, to enforce regulations and more importantly, maybe interpret regulations, something that precedent had been around for a long time and threw it out. It does have a tech angle on it because the FCC is one of those agencies, and they're the ones who are about to return us to net neutrality. Would this undermine their ability to do that?
I'm going to go with maybe. Although it did dawn on me today that one of the other things that it would ruin was President Trump was trying to get the FCC to somehow adjudicate via Section 230, and even though Section 230 doesn't even empower the agency to speak to it. So I think that's the sort of thing where this case would really actually hurt those terms.
The Verge wrote that it does impact not only net neutrality, but the right to repair.
It's going to impact any agency. It's going to impact any agency. I think the question, and I have to read the decision more closely, and we also have to see how things shake out, is how does it affect all the agencies? So if we take a step back and we think about this a little bit more globally, there is some wisdom in being a little concerned about the Chevron doctrine, which is the Constitution sets up that the legislation happens via Congress, not the executive branch. On the other hand, it's a modern world, it's complex. The Constitution doesn't allow agencies to exist, and they got to be able to do something because we can't actually practically have everything go back to Congress, plus Congress doesn't necessarily have expertise, but agencies can. So there is going to be some tension between where is effective governance, but then there's a problem of we gave Congress the power to legislate, and if we give too much power to the legislature, that's unconstitutional because now the executive branch is in the legislative business. There's probably a way to draw this line. And what a lot of these things with the Chevron doctrine has to do with is where is that line drawn? What is acceptable for Congress to have said via statute that the agency can do, and what is not acceptable for Congress to have told the agency it's acceptable to do? The problem, I think, with this decision is I think it was so indifferent to the effects of the decision that it's probably drawn the line in a crazy, not particularly useful way. But I don't think it completely said that agencies can't do a lot of what they're doing. But a lot of this doctrine is in case of some tension where the statute's unclear, can the agencies gap fill? That will defer to them for the things that we're not specifically clear from the statute of what they can do or not. And at this point, the answer says no if it's not specific.
So it sounds like my hair should not yet be on fire, but it's just smoldering a little bit.
No, let me say a lot of credible people say your hair should be on fire. Okay. So let me not completely pull away from that. But I'm trying to also think pragmatically. And I mean, this is going to be a mess. I don't entirely know.
I've heard it said, I don't know if this is the case. You sound like you're less adamant about it, but that really this was a power grab by the courts to say, no, we should be deciding, not federal agencies.
Well, it has the effect of, okay, so...
Neither Congress nor agencies, it's our job.
So what's going to happen to a dispute? An agency does something, and somebody's unhappy with what the agency did. There's going to be a lawsuit. Chevron deference said, yeah, we'll probably kind of default to the agency unless they did something, really crazy. Now I think they can't really have that same default, but that means that it's the courts that are deciding that default isn't wiring, and the effects of now the courts are going to have the most effect for what is the rule going to be? What is the regulatory effect going to be?
This isn't a 180-degree change. This has been slowly eroded over the last 20 years.
So I think one of the dissents was talking about, yes, like even just since 2016 or this year, the court has been chipping away at various things agencies have been doing and saying, no, you shouldn't have been able to do that. You shouldn't have been able to do that. And now this is very clear language saying that Chevron deference, which you thought was a thing, it's not a thing anymore. So now there's a vacuum. And the question is what, if anything, will fill the vacuum? But it's probably going to be, and one of the reasons the hair is on fire is it's probably going to be a lot of chaos. It's probably going to take out a lot of good rules. It's probably going to make agencies very confused. It's going to make regulatory efforts much more expensive. And to the extent that they provide protection to the public, it is going to be a lot harder for the public to actually be protected.
And also from the tech sector, there are, for instance, that one of the weird little niches this affects is H-1B visas. And as you know, the tech industry has been saying we need more immigrants using H-1B visas working in our companies because we can't find Americans to do the job. The H-1B visas are issued by, obviously, a administrative agency, a federal agency. Now, if employers want to overturn the narrow H-1B choices that these agencies have made, it's easier for them to say, no, we want these guys, and the agency shouldn't be able to overturn that visa.
Well, I'm thinking very much like you asked me, I seem to be a little bit sanguine, and you're asking me why. Like, is that because it's not that dangerous or not? And I'm thinking about it as a lawyer where, okay, you've got a problem, and I'm kind of like trying to think about, well, how do you litigate around it? What are your options and things like that?
Here's what a professor of immigration law practice at Cornell told The Verge. In the past, employers have had a hard time overturning narrow interpretations of H-1B issues because of Chevron deference. Now, however, people who feel that the agency is too stingy in its interpretation of various visa categories may be more likely to seek court review. Now, that doesn't mean that they're going to win, but they at least don't have to bow down to the agency immediately.
Well, so there's an irony to this, which is Chevron deference was originally criticized by non-conservatives when it first came out. Like, Justice Scalia was like the leading light who was like, we need Chevron deference. It was unpopular when it came out. Doing away with it, in theory, actually opens up to some good results that...
Depends where you are.
Well, in theory...
What court has jurisdiction, right?
Well, we can't explain the Fifth Circuit, but let's presume that the Fifth Circuit isn't just doing their Fifth Circuiting things. For all the other reasonable circuits, there actually could be some upsides to doing away with Chevron deference, which I don't think we should ignore. But there's a lot of cynicism, and I don't think it's misplaced, to suggest that Well, what essentially happens is the courts are going to call it as they see it or as they want it, where, okay, great, so Chevron deference being done away with is going to help both the good causes and the bad causes.
It's now a patchwork system.
And this was the concern people had with 303 Creative. They're like, I was arguing with people because I'm like, it's a good doctrinal decision. And people are like, yeah, right. The courts will stick with it when they like the result, and they'll, ignore it when they don't.
You really can't say that Mark Zuckerberg or Google would be celebrating this decision, because it really just depends on the court that they're going to go to.
Actually, I think one argument is no business. So in theory, businesses are cheering. And the argument is the businesses shouldn't be cheering because it's made the businesses do better when regulation is predictable. They don't like regulation,
precisely the problem.
But if there's going to be any predictable regulation is better than less regulation but total confusion.
This was the argument you made about the privacy, the federal privacy statute.
Exactly.
Better to have a federal privacy statute than a bunch of patchwork state statutes. This moves us back to that. It's a little confusing what the business environment that everyone is going forward in. If you're Google and you're doing it in Mountain View, that might be easier than if you're Chevron and you're doing it in Texas. I mean, it's just really going to vary.
Every business in every sector affected by every agency, it is now open season on what will happen.
We don't know what's going to happen.
And, some businesses are like, well, we'll get less regulation that way. And if we get regulation we don't like, we can challenge it more easily. But, you've just walked into chaos. You are better off
chaos
not having
is always
chaos.
bad for business.
Exactly. And I think, that's the why the hair should be on fire thing, too. We've lost a lot of predictability, and we don't know. It is kind of scary to look at tomorrow and not have any idea what tomorrow is going to look like.
Well, I want to thank you all for watching the Kathy Ellis Show. We are now going to adjourn the class and bring in Doc Rock and Ryan Shrout. I appreciate you guys letting me.
To me, it was so good.
It's good to have this time.
To me, it was so good. Yeah, because I want to hear from somebody that's being sensible. And a lot of the reactions so far online are extremely knee-jerky, or, people tend to talk about how does it affect me, right? And I understand that reaction, but I want to hear what the overall picture is like.
Agree.
So it was almost like Kathy just gave us a pretty dope GPS on the whole situation.
That's why we love her.
And we still might be lost, but at least we have some directions we can kind of follow.
Actually, that's my pet name for Kathy is Dope GPS. So we're so glad you're here.
I was going to say something, and now I'm just stunned. I think everybody cares from how is it going to affect them, but I'm not entirely sure people necessarily understand what that answer is going to be, for the same reason that some businesses were cheering, and that probably is, they think it's good for them, but if they thought a little harder or looked at it from the right perspective, maybe they'd realize this isn't good for them.
Well, Kathy's not done for the day. Yeah. Our Dope GPS will return in a moment because we have lots of other stuff, court action going on. The Internet Archive fighting its appeal over the publishers. The Internet Archive says that we had to pull 500,000 titles off of our site because of the publishers' court victory, but they're appealing, and we'll talk about that and a lot more. And of course, we're going to talk about the Copilot Plus PCs, and I want to get Ryan Shrout's take on the new Snapdragon Elite now that we've had it for a week or so. Doc Rock is also here. He is with Ecamm and a YouTuber in his own right, and has the most purple background of any of our guests on the show. Not just today, but any day. It's nice to have you, Doc. Did you say before the show that you used to be a male stripper, or is that just, did I mishear you?
No, I was joking, but I did used to have to DJ those nights at the club because somebody got to do it.
Somebody's got to play the bass. Yeah.
We would Junkin' Po, or what you guys call Kai Bai Bo or whatever, Rochambeau, whatever. It's the same thing, rock, paper, scissors. And I lost way too many times.
Yeah, Doc, you got to go out to the Bada Bing tonight and play for the people. Anyway, good to have you. I'm glad you don't have to do that anymore. That's a good thing.
Thank you.
And we're so glad you're all watching This Week in Tech this week, brought to you this time by Lookout. Today, every company is a data company, and that means every company is at risk, right? Cyber threats, breaches, leaks. This is the new norm, and cyber criminals are growing more sophisticated by the minute. Here's the problem. Boundaries no longer exist for your data, right? What it means for your data to be secure has fundamentally changed because your data is everywhere. Enter Lookout. From the first phishing text to the final data grab, Lookout stops modern breaches as swiftly as they unfold. Whether on a device, in the cloud, across networks, or working remotely at the local coffee shop, Lookout gives you clear visibility into all your data at rest and in motion. You can monitor it, assess it, and protect it without sacrificing productivity for security, because your employees want to be on the move. Your data wants to be on the move, but you can still secure it no matter where you are. And I have to say, with a single unified cloud platform, Lookout simplifies, strengthens, reimagines security for the world that will be today. Visit lookout.com today to learn how to safeguard your data, secure hybrid work, and reduce IT complexity. Lookout.com. We thank them so much for their support of the show. Lookout.com. We appreciate it. Speaking of security, there was a very, very good news story today. Interpol making major arrests all over the world. Get ready for this number. They arrested, according to Interpol, 4,000 scammers, people who are pursuing online scam networks. 3,900 suspects arrested, $257 million in illegally obtained assets. This was Operation First Light in 61 countries. Targeting phishing, investment fraud, fake online shopping sites, romance scams, and impersonation scams. And, you know, I mentioned this on Ask the Tech Guy because that's our show for normal people. The show for the people who are, of course, the victims of these scams. Them, their families, their parents, their elders. Police intercepted $135 million in fiat currency. That's regular money, and $2 million in cryptocurrency. Other assets worth over $120 million US were seized: real estate, high-end vehicles. There's a picture here of the watches they confiscated. This is in Brazil. Expensive jewelry and other high-value items in the collection. There's some nice watches there. This is all ill-gotten gain. These are people who called your grandma and impersonated the bank or sent a text saying, hi. You've all gotten those texts. They often end up in a big scam. Authorities in Australia recovered 5.5 million Australian dollars on behalf of an impersonation scam victim. That's one victim. After the funds were fraudulently transferred to bank accounts in Malaysia and Hong Kong. I mean, the numbers are staggering. 163 computers seized, 350 mobile phones. The data all handed over to Interpol. Singapore's Anti-Scam Center and Hong Kong's Anti-Deception Coordination Center prevented a tech support scam. You've gotten those. Pop up on your computer screens as you've got a virus, call 800-73-SCAM. A 70-year-old victim was saved from losing $281,000 worth of her life savings in one of those scams. So good news. I wonder, though, Doc Rock, if this means the end of these online scams.
Well, I want to hope so, but they'll come back soon. There's so many crazy ones out there now, and I legit just got sent one yesterday that was almost good. But I like to check them, right? So I have this kind of like dummy browser thing that I go into and check to see where these links go. And it was a Hawaiian Airlines page that's like, if for our 95th anniversary, we're going to give you a round trip to Bora Bora.
All right.
All exclusive paid, whatever. And the Facebook group was called Hawaiian Airlines Fans.
Oh.
And they did such a good job setting that page up that I can see a lot of people who paid less attention in school might fall for this. And then it's the thing that they did is you know how you could have a mini chat bot or some of these other bots where if you put in a hashtag or an @ something in a Facebook group message, it will send you a message directly to your Facebook Messenger, right? In IG, there's a really cool app by my friend Jeff called Stampede Social, does the same thing. If you put like hashtag Leo, it would send links to the next shows that are going to be in, the club, right?
Yeah, I like that.
So they did is they set this type of bot up so that you would put in this hashtag that you need to put in order to win, and it would basically send you a direct message to Messenger. Well, anybody who starts commenting with that person back and forth, and what you can do with web trackers, you immediately start sending them all of the info about you, right? Because there's apps like Group Grabber that if you answer this, it automatically sends your name, your address, like all of the things that you don't have because you don't use Ghostery or something of that nature to make sure these trackers are following you. So in a very simple page, I'd literally watch hundreds of people that I personally know answering this thing, and I'm like, don't answer that.
What are you
my God,
doing?
delete that right away. Do not conversate with them in Messenger. Just delete that right away.
We had an advertiser,
when you go to
a
the
potential
URL page, it was clean. You really thought it was them for a second,
Right.
and then I started to notice design problems because I know the designers of the actual Hawaiian website, and I'm like, yeah, this is not it.
you have to have an eagle eye. That's the problem, right?
Yes, that's the problem.
And I feel like I don't know what's true or not anymore. In my email on the web, let's see if we can hear Ryan. Try your audio. Nope. Nope, nothing. I heard you at the beginning of the show, Ryan. All right.
Read his
maybe
lips.
maybe just need to reconnect, Ryan.
Why don't you just drop us and connect again? I mean, I don't know if that's going to fix it. It's like the equivalent of the IT crowd. Reboot your computer. Have you rebooted your computer lately? 80. So here's one too. 88 local youths in Namibia were rescued by the police. They were slaves, basically, forced into conducting scams. And this we know is true. You've seen the piece that the New York Times did a few months ago. There are a lot of the scammers, the people you're getting these texts from, are actually trapped.
I have some concerns. I followed into the press release, and I'm being cynical, but I'll tell you what set me off. 3,900 arrests.
Yeah.
That's a lot of people.
No kidding.
And so I want to prompt. It
Remember,
prompts the
that's
question.
61 countries.
It's 61 countries. Over what time period? Distributed across what countries? Do we fully trust the governments that are doing that? What are they putting all these people?
This was led by the Chinese Communist Party. This was out of China.
I mean, I think the thing that is probably significant and possibly effective is it looks like they broke up a network, and it's also that they've probably found some
Several
assets
networks,
and
they said.
several networks.
Yeah.
I mean, some of that is probably going to be good, but it's hard to say, yay, go policing efforts of countries that are really not known for due process in their policing efforts.
In fact,
and it's a ton of people.
It says first, and this is the Interpol press release, First Light operations are funded by China's Ministry of Public Security. So that is, you're right. You see what I'm saying? You never know. I feel like I don't know anymore what's true or good.
Well, can you hear me, Leo?
I can hear you now.
Coming through now. Great.
Yeah.
All I wanted to say the whole time was I'm glad for me seeing the government go after and accomplish something that I really needed to get done was prevent all this fraud stuff from happening. And I'm sure you saw the news. I don't know if you talked about it prior about like Mark Cuban having his Gmail account hacked.
No, I didn't see that. What?
Yeah. He had his Gmail account hacked, and he was like on Twitter asking for Google to help get it back.
That's terrible.
So now that's the Mavericks excuse. Go Celtics.
Yeah, that's why the Mavs lost.
But
So no, he says he was hacked after receiving a call from a fake Google rep.
Yeah, and see, I'm trying to say it's not just like he's technologically aware, right? He's not an 80-year-old man. This isn't something that just catches those that aren't technically capable, right? This I get messages I bet I get two or three a week of a text message, hey, how's it going? Right? And
yes,
and I often and
now.
I'm like, and I stare at the phone number and I go, do I recognize this phone number? What area code is this even from? Like,
all the time.
And they're all awful, right?
All the time. Yep.
Yeah.
You can't believe
I've gotten so
anything
good
anymore.
at guessing area codes because I have to keep checking all the time. Now I'm starting to remember them.
Some of them are more than just high. I mean, a lot of them are just high. This is, by the way, these scams are called the pig butchering scams. They're often perpetrated by crime rings that are holding people against their will. They take their passports, they put them in dorms, and they're responsible for scamming you. They're real people on the other end, but usually it starts with hi, and then actually I get more sophisticated ones like, hey, I can't come into work today, so I'm sorry. Can you ask George if he can take my shift? And then I'm supposed to feel bad and say, oh, you know what? I'm not your boss. You got somebody. And then what they say is, oh, I'm sorry. Hey, what's your name? Leo. Oh, gosh, Leo, I'm so sorry. I thought I'll text my work. Where are you? I'm in Petaluma. Oh, that's a nice area. I'm in Taiwan or Singapore or whatever. And you get in this conversation. Eventually they get you there. Usually they want you to buy crypto, fake crypto, which you send real money to buy. And then you never hear from them again. So this is the tweet. This is hysterical. From Mark Cuban. Hey, Google. It's kind of nice if you're a billionaire and you can just go, hey, Sundar Pichai. Hey, I just got hacked at my mcuban@gmail.com because someone named Noah at and he gave a phone number, 650-203-0000, called. Mark, do I have to explain how this works to you, Mark? And said I had an intruder and spoofed Google's recovery methods. If anyone gets anything from mcuban@gmail.com after 3:30 p.m. PST, it's not me. But it's really ironic that Mark Cuban accuses them of calling from Google's 605 number, 650 number. The phone number that Cuban received a call from is the same one associated with Google Assistant, but Google says on its account recovery page, it doesn't ask for passwords or verification codes over the phone, email, or messages. No one does anymore, and no one should. And if they do, you should not give it to them.
I'm concerned there's actually a number of companies whose security paradigms actually involve you giving too much information over the phone.
Are there? Really? Still?
I'm not happy with United Airlines and the way they authenticate, and I yell
hate
at
secret
them.
questions. They do secret
questions, but
That's
anything where you're looking for something where if you can confirm it, it means it's not hashed and it's sitting there in plain text. Like some of these things of the way they authenticate are with, I mean, you always have this tension between what is practical and what is secure, but some of these are really poorly designed. I'm like, did you hire somebody who knew what they were doing to set up your protocol? Because I'm not even that expert, and I think there's problems with it.
I've changed banks, but for a long time, my former bank, would send me a text message to verify my account, and I always thought, we can do better, can't we? The problem is that...
Oh, man. Amazon still does text messages. And I'm like, please do not do that.
I know.
The only one time I've ever been spoofed was Amazon, and someone bought like $8,000 worth of Xbox cards, to get Xbox Live. And so the agent and I are on the phone for like an hour, keep resetting the password, and the charges are going through to the point where they almost blame me, saying, no, you're still buying these things. And I was like, listen. And we looked at all the stuff. We're going over and over. We're trying to figure it out. And we finally figured out that the country code, instead of being just 1, was 6-1 or 9-1, whatever the heck Pakistan is.
It wasn't here. Yeah.
And so they had spoofed my phone number, which is why phone number is the worst way. And if someone stole your device and has it open, and you use that to authenticate the bank, hello? That's super stupid.
I got to say, people assume Mark Cuban knows what he's doing, but I'm not completely convinced. That tweet alone shook my confidence in him. And it turns out last September, he lost $850,000 from his crypto wallet because he was, quote, pretty sure he accidentally downloaded a version of MetaMask which contained malware.
Well, I think some of it in his position is Google does have, I think, a different regime for certain
he
targets.
got his account back, I got to point out.
Well, I think for certain targets, Google may have different relationships with certain users, and it's possible that he was more easily spoofed because he really thought it was a conversation vis-a-vis the particular type of relationship he had with Google.
This has been my position all along. You never want to be rich and famous because you get hurt. more. You fly in private planes and helicopters.
That's my excuse, Leo.
Yeah. You really don't want to be rich and famous. It just doesn't
nothing
pay.
but ignominy for me. So.
Yeah. It's ignominy. Say it again.
I think it was wrong.
Ignominy for me.
Ignominy for me.
Ignominy or nothing. That's my motto. Yeah, I like it. All right. That was a good sidebar, by the way. Thank you, Ryan. I did not know that he got hacked. So,
does this can you hear me still?
Yeah, you're on. You're on your laptop mic. I guess your other mic died.
No, I'm on these AirPods now because whatever microphone I'm using, I guess, is cutting out. The software it still says it was working fine. So,
the software lied.
Let's talk about Julian Assange. How about that? So this has gone on for a long time, and I don't know how I feel about this. Just like I didn't know really how I felt about Edward Snowden. And it doesn't help, by the way, that Edward Snowden is now living in Russia happily. But Assange is now a free man. He did a plea deal, pled guilty one count of espionage in court on Wednesday, and they said the 5 years that you've been in detention in the UK counts, and you're free. But he did have to plead guilty to this one count of espionage. His followers and friends, he was the guy who ran WikiLeaks. And the reason he got in trouble was WikiLeaks published what turns out probably was a Russian hack of the Democratic National Committee's email. And it looks like, in fact, his cutout was Guccifer, who has since been identified as a high-level operative in the Russian military intelligence, who gave him this information. And there's even some question about whether he solicited this information. He's been trying to he's been trying to avoid extradition from the UK. This is one of the longest-running national security investigations in U.S. history. Assange, despite pleading guilty, denies the accusations. WikiLeaks wrote in a statement posted to X, Julian Assange is free. He left Belmarsh Maximum Security Prison on the morning of June 24th, having spent 1,901 days there. The case centers around publishing more than 750,000 stolen U.S. documents by WikiLeaks between 2009 and 2011. Organizations like the Committee to Protect Journalists have warned for years that prosecution of Assange could imperil the ability of journalists to obtain and publish classified information. And you may remember that just before this email release, WikiLeaks published video that showed that the United States had targeted civilians with its drone attacks. I think that was that Reality Winners material that she handed over? I can't remember. Both Donald Trump, Hillary Clinton have attacked Assange. WikiLeaks published a trove of emails in 2016 stolen from the DNC. It won Assange praise. I'm reading from a Wired story on this from right-wing figures. Later revealed to be the work of notorious Russian hacking group Cozy Bear, affiliated with Moscow's GRU military intelligence. What do you guys think? Assange, a legitimate journalist pursuing journalism and persecuted, not prosecuted by the United States government for doing so, or a willing or unwilling, witting or unwitting dupe of Russian intelligence?
Possibly both.
Or both.
Because, so the journalists are concerned because it depends what he was doing. There's this old case, and it's actually not that old. There's a case that currently exists called Bartnicki versus Vopper, and that is a case that stands for the proposition that you can report on information even if that information was wrongly obtained, but it wasn't wrongly obtained by you. So one of the open questions with what was going on with Assange was, is what he published something he was publishing entirely as a journalistic function of information he was provided to where he had nothing to do with its sourcing, or was he too direct with the sourcing and having engaged in illegal behavior that generated the information that then he reported on? And it is possible that in the course of his career, both things have happened. So the journalist's concerns are completely valid for when he's just a neutral and he's legitimately doing reporting and he had nothing to do with illegally sourcing material. You don't want prosecutions to happen to punish that sort of reporting. With his record, it was a little less clear that all of the reporting he truly did as a neutral intermediary who happened to have somebody else sourced it and just gave it to him with no conspiratorial contribution by him. I don't think we know. I guess we'll never know, but that's sort of the tipping point of whether we don't know how we feel about Assange, because some of it depends on what the facts are.
Yeah, and I don't know if we know the facts. It's perfectly possible that the U.S. government scapegoated him.
I think both things have happened, but there's also the argument that the government scapegoated him just because it was so embarrassed and so upset. And I guess my question is, how legitimate was the scapegoating? Like, was it pure scapegoating, or did they actually have a leg to stand on to actually complain? And I'm not 100% confident in my own government's zealous pursuit of him. But on the other hand, I'm not entirely confident with how Assange has comported himself, so there's a part of me that thinks maybe the government did have a leg to stand on. I don't know. It's probably going to be completely dissatisfying for both parties. So in a sense, this is just as well, because otherwise now it's resolved. Now we can move on. But yeah, it's hard to get a feel good out of any of this.
The video, and I got it wrong a little bit, from 2009 was, WikiLeaks called it collateral murder, showed a crew of an Apache helicopter shooting a wounded Reuters journalist. An anonymous U.S. military official confirmed the authenticity of the footage. So that was legit, right? That was something that was a war crime, in effect, admittedly a war crime that the United States committed. But I'm not such a patriot that I think, oh, that's fine. So I think that was legitimate journalism.
I think he definitely has engaged in some legitimate journalism that has been unfairly targeted. I just don't know if all of the quote-unquote journalism he did falls into that category, or if there are allegations that have sounded reasonable about him being a little bit too close. But on the other hand, maybe it's also something that we don't really know, and I think if we had to have a tipping point, I'd rather have journalists have a freer hand, even in sort of the gray areas, than what happens if the journalists don't have as free a hand. I think journalism takes a hit, the free press takes a hit, the First Amendment takes a hit. I'm always going to go on team. I'd rather have too much protected than not enough protected.
Yeah.
Any thoughts, you guys?
Also kind of crazy
when you talk about like law enforcement in general, right? This is something that was talking about just yesterday. Sometimes you have any law enforcement thing in any particular case where the person jumps to conclusions based off of their experience. There's other times where that person just jumps to these conclusions because they're just a heavy-handed, like, hang 'em high type, Judge Dredd type person. They just want to take everything out. And the horrible part is when a case fits in a situation where everything lines up directly in the middle of that. It could easily be said with pure accuracy, this person that's in the Leo is not you, Laporte, is jumping to conclusions and making assessments and just want to hurry up and wrap this case up for optics. But then the person who's, quote unquote, did something wrong, they did enough shady stuff to deserve somewhat of a heavy hand. So it's hard when that sits sort of right in the middle and there's not a key case of over-enforcing and there's not a key case of caught red-handed. And those always are the worst cases. But I do think it's better to, even if he was scapegoated, it's better to at least put light on some of this stuff. But yeah, I kind of sit with Kat. Like I'm deeply conflicted.
Also, I want to correct myself. That video was not leaked by Reality Winner. That was the Chelsea Manning leak, and of course she served time for that. And her sentence was commuted, I think, by President Obama.
I'm sitting here trying to. It's hard to imagine that this was all that long ago. First of all,
I know.
That this all took place back then.
15 years ago.
I would say, I agree with, as somebody who was a journalist for a long time myself, I obviously kind of err on the side of protection of that side of the world. Also, the idea that, hey, maybe we did all these bad things, but you obtained the documents illegally doesn't really hold a lot of water for me. Like you can both break the law and he can be held responsible for that, but also it doesn't take away from the severity of any of the actions that were taken, right?
Right.
And so I think that needs to be considered as part of it.
An example from my own youth is the Pentagon Papers. Daniel Ellsberg leaked those to the New York Times, revealing what the United States had been doing in Vietnam. Ellsberg may have committed a crime in leaking them. Chelsea Manning may have committed a crime in leaking that video. She served time. But that doesn't, if the journalist, it's my understanding, the rule is if the journalist doesn't suborn that crime on the part of Chelsea Manning, doesn't go to Chelsea Manning and say, hey, can you get me that? But does receive the information and publishes it. The New York Times was never prosecuted for the Pentagon Papers, even though Nixon wanted them to be.
I think there's two levels of what do we do about situations like these. One is the situation of that what you just described, that some intermediary has sourced the information and then handed it to somebody else who had nothing to do with the sourcing of the information and just published it.
Right.
And I think in those instances, it should be clear that the journalists who publish it really shouldn't end up in trouble for it.
That's not a crime.
But then there's the second question of, well, what about the people who are sourcing this information, liberating this information, acquiring it in other ways? Because to some degree, they may be doing a public service because it may be revealing bad things that the public needs to know about. And I think that's a tougher call. Because
I agree.
in some of these instances, I'm very glad it did get exposed.
I think Chelsea Manning did the right thing.
But what is the principle that scales where we don't have just everybody going to lunch or going to town and then...
Same thing with Edward Snowden. I mean, he revealed a lot of stuff that was very embarrassing to the NSA. Yeah. Was he a hero or a goat? There's still debate over that.
Well, one of the issues that did come up with Edward Snowden is that releasing it wasn't his first choice. It turned out he had no other avenue.
He tried, I think, really hard to do the right thing.
So I think from a policy standpoint, if you don't want everybody independently sort of taking everything into their own hands and posing their own judgment, which may be wrong, you do kind of need a mechanism for, well, what do you want people to do instead? And I don't know if we'll ever be able to have a perfect one, but I don't think at the moment we have any. We don't seem to have any sort of framework for this or any coherent response to these types of issues.
It was the assertion of the government that, and there were chat logs indicating that Assange had actually had a conversation with Chelsea Manning and actually showed her how to exfiltrate the data, asked for that data. So this was the government's position, was he was complicit because he provided her with the information she needed to get the information out.
I think I'd also want to see that the government had a coherent framework for why it would be okay to go after Assange, but don't worry, it wouldn't translate into going after any other journalist.
Right.
And I don't think none was getting articulated in a way that the public could be confident in.
And I think your first point is still the best point. We don't know the whole story, and we probably never will know the whole story.
Unless somebody leaks it.
You could leak it to me. I'm not asking you to. I'm not saying you should. I'm not telling you how. But if you wanted to, I'd be here for you. Actually, we do that all the time. A number of our panelists give out their signal number or ask for tips. Paris Martineau has her signal number in her lower third. So that people can give her tips. And she says she gets quite a few tips from the Twit crowd. You guys know stuff, don't you? In fact, I know we have a lot of people in intelligence who listen to our show, and a lot of intelligent people as well. Kathy Gellis, speaking of intelligence, is here, attorney, and she is admitted to the Supreme Court, so she can go.
Write briefs.
You can write briefs. She does, in fact, for the Copia Institute, which is an arm of the Tech Dirt, and does some very good work. We're really glad to have you here explaining what's going on in the court system. Doc Rock, the purplest of them all. He actually, we should give you credit because you served our nation as a medic, yeah. In was it Afghanistan or Iraq? I can't remember.
No, I'm older than that, Leo.
Was Korea? Was it Vietnam? Where?
Germany.
Okay, not that old. Not that old either.
Anyway.
I'm the mid '80s, so I went to Grenada, but not fight. But I went there and I went to Kuwait. But yeah. Anyway,
Kuwait. There you
the
go.
funny thing,
Kuwait.
the purple is because of Alzheimer's.org.
Nice.
Like
Support
I said,
that.
I deal with. Yeah, so that's the reason why I have purple everything, and I love Prince.
We walk in the Alzheimer's walkathon. My mother-in-law passed from Alzheimer's. My mom now has been diagnosed with it, and I know it's on my list of things to do. So I appreciate the purple, and I think you're absolutely right. Let's support research, because this is one I think we can beat. YouTube.com/DocRock. And thank you for your service, of course. And Ryan Shrout, who is now on AirPods, much to his dismay.
Yes, very much so.
Signal 65 is the new job. What do you do at Signal 65?
So a lot of what I was doing before I went to go work at Intel, right? So kind of independent third-party testing and validation of PCs, data center products, software services, things like that.
I think that this is such a skill, and it's so, you see so many YouTubers putting their laptops in the freezer to see if it's faster, things like that. That really knowing how to do these benchmarks, really knowing how to test hardware and software is so important and so valuable. And that really is
your laptop will be faster if you put it in the freezer.
It will.
That it is.
It's harder to type
usable,
on,
but it is faster.
Yes,
yeah.
it's faster, but the keys don't work as well. But you know,
yeah.
Signal65.com. Great to have you on board. Our show today brought to you by 1Password. And by the way, this is such a cool story because you may remember Collide, which is an authentication, a hardware and software authentication tool used with Okta. For many years was on our network advertising. They were acquired by 1Password, and now 1Password has a new product they call Extended Access Management. In a perfect world, end users would only work on managed devices with IT-approved apps. Oh, yeah, right. But every day, personal devices, unapproved apps that aren't protected by MDM, IAM, or any other security tool enter your network. Not much you can do about it, right? Well, there is a giant gap between the security tools we have and the way we actually work. 1Password calls it the access trust gap, but they have found and created the first ever solution to fill it. 1Password Extended Access Management. It secures every sign-in for every app on every device. Of course, it starts with a password manager you know and love, 1Password, and the device trust solution we've talked about so often before, Collide with a K. 1Password Extended Access Management cares about user experience and privacy, which means it can go places other tools can't, like personal and contractor devices. It ensures that every device is known and healthy and every login is protected. So stop trying to ban BYOD or shadow IT. Start protecting them with 1Password Extended Access Management. This is a marriage made in heaven. Check it out at 1password.com/twit. We're so happy for the Collide team and the 1Password team. That's the number one, PASSWORD, 1password.com/twit. And we thank them so much for their support of This Week in Tech. Look at this. Maybe this Supreme Court decision will get this out of the FTC. Microsoft's. Oh, I'm sorry. It's not the FTC. It's Europe. Can't do anything about that one, SCOTUS. The European Commission says, I don't get this. Microsoft bundling Teams with Office breaks antitrust rules. It's abusive, says the EU. This is one day after they took aim against Apple. In fact, by the way, I should mention. Well, I'll get to that story. We'll do the Apple story in a bit. It's going after Microsoft for tying. This is what they got in trouble for with the Internet Explorer back in the 90s, tying Internet Explorer to Windows. The European Commission Tuesday said its preliminary investigation had determined that Microsoft breached the 27-member bloc's antitrust rules by abusing its position in the market for productivity software, including Teams and the Microsoft 365 suite, even if customers don't have a plan for the service. or by providing a free 1-year trial on the Office 365 service, Microsoft is hurting competition. I'm sorry.
Is there competition for Office today?
I think Teams.
Google Docs, I guess.
I have to think Slack is behind this, because Slack has notoriously been pissed off about Teams and Microsoft Teams.
Yeah, but I'm pissed off at Teams just having to use it.
Teams is awful.
There's a point of it's an inferior product in the market.
Is there anything wrong? Yes, it. Oh, now I'm reading the story from Quartz. The Commission's inquiry began after it received complaints from Slack, which has been acquired by Salesforce, and a German video conferencing provider, AlphaView. I am sorry. Bundling Teams with Office is not anti-competitive. It doesn't change anything. I don't get it.
It's a slight against humanity, if anything.
Yeah.
That's about it.
It does have some shades of, and you've also bundled your browser. So, but
I always question look, every operating system bundles a browser. Even Linux comes with a browser because you can't use an operating system without a browser.
Well, don't decide from now. We're talking about in the 90s when it was first getting bundled. Okay. So at that point, it was a bit more using some leverage to tie you in, because also at that point, the browser was proprietary and not necessarily adhering to standards, and it was going to skew so much of the open web by kind of killing the open web and making it do it Microsoft's way.
Yeah. Well, at that time, too, your browser, you had to go get a magazine and get the disc off the front or buy some random book at Barnes & Noble to get it because you couldn't use a browser to get a browser at that point. Right. So you had to have something, right? In a lot of cases, you legit went to go get a magazine or a book that had a disc on the front when you're setting up somebody's computer until you figured it out.
Yeah.
So as Trust Noan in our Club Twit Discord says, the anti-competitive part is that every computer that comes with Windows comes with Teams as well as an Office trial. But, what about Notepad? What about...
is the bundling complaint for Windows or is the bundling complaint with Office?
They say Office.
Yeah.
I think it's Office and Teams in Windows. So it's part of that Office is preloaded.
Right.
Teams is preloaded. You get a free trial for X number of days.
That's right. They say the free 1-year trial is the problem. Yeah. Yep.
Yeah.
But you know why this is so weird now? Because... yes, they're giving you the free 1-year trial, this, that, and the other thing. But you know what's a free forever your life trial? LibreOffice or Google Docs or all these other things.
That's true.
And now the browser's built in. If you have a problem with it, open up the browser and get something else. There's so much free stuff out there. You can do Zoho Office or whatever.
That's true.
So this is a really stupid case, but in a way, a lot of the stuff that the EU has done in these situations has been, like complaining about being wet and you live in the tropics. Like, it's just really silly.
Yeah, so there's the articulation of the complaint has some similarities to the browser tying, where you are distributing one product and you're tying another product to it, so therefore your presence in the market is different because
all operating systems are bundled with some application software.
So I think
the question is which software is okay to bundle and which isn't.
Well, so I think the question is the inquiry can't end at the fact that it just got distributed with something else. You have to look at other effects on the market.
What about the Minesweeper folks? I mean, all the competitive Minesweeper games.
You can't get that anymore. It's not pre-bundled in it. But
I was thinking the same thing about chess and Grandmaster. Or Grandmaster 3000.
There
versus,
you go.
The built-in chess.
So we accept that some software can be bundled without that being anti-competitive.
Well, some of it is like, what is the effect on the market? The effect on the market is, there was a third party here. Like, it's not preventing anybody from using Slack. It's not preventing anybody from using the third parties. It's not preventing
But it gives
Zoom.
them a leg up because you have Teams.
I guess so. Then we were all joking at it because you have Teams and you're so miserable that you immediately want to go find a competitor. But
Leo, you said what software is bundled with the operating system. I think the more important question is when does it become a part of the operating system versus when is it not?
Right. You can take Minesweeper or Klondike off, and you still have Windows.
But you can't have a browser.
Yeah.
You can't not have a browser and be functioning, right? And I think you're pretty close to a day and age where you can't not have a communications utility of some kind and have an operating, functioning PC experience. And that to me is where I think the big debate has to happen, right? When we start to look at all the different AI integrations and things like that, I bet this comes up again, right? Because you'll have OpenAI, or maybe you have OpenAI integrations or Copilot integration, and you want to have your own third-party integrations as well, and you're going to have third-party AI companies that want to make that same kind of argument.
Yeah, but I think you'd still have to go beyond that, because I don't think that is enough. First of all, I'm not quite sure that you have to have some sort of chat service bundled into it. But then I'd want to look at what's the difference between a proprietary chat service versus a protocol-based chat service. What's the effect on other competitors? Is this really undermining them? Are they still able to compete? You have to look at a lot more other than we gave you another piece of software when you got the piece of software you were looking for. Because if that's where we're drawing the line, I think you do kind of gut a lot of these operating systems, or even any sort of fancier software, and that would be bad too. I think European regulators don't care, and they're perfectly happy to slice and dice any piece of software they don't like.
Does Apple get criticized for bundling
Safari,
iMessage, or Safari,
or we have a whole green bubble fight once a week. But then I like Ken's comment. Ken's comment in the club is very, very, very well taken. What browser can you install in your Chromebook?
No, that's right. Just Chrome. That's the only one. It's a good point.
It's like EU picks the fights, but they
there is a difference. Chromebooks do not have market dominance. Microsoft has market dominance, right? You can't have an antitrust action against a minority.
So does Lenovo, right? So does Lenovo. So why can't Slack just pull up their pants and be like, "Hey, Lenovo, can you drop Slack in every one of these machines, and we'll pay you for it?"
Oh gosh, I don't
just
think
like Apple paid Google to be Google to be the search engine.
Microsoft, by the way, says when the commission began this inquiry, because this is the result of an inquiry. Yeah. This is how the commission works. They do an inquiry, they announce an inquiry, and then they say, our inquiry produced this result, which in this case is, we think it's antitrust violation. When they opened the inquiry last July, almost a year ago, Microsoft responded by offering, it says, some suites without including Teams. How about that? Regulators say the changes are insufficient. Brad Smith said in a statement, having unbundled Teams and taking initial interoperability steps, we appreciate the additional clarity provided today and will work to find solutions to address the Commission's remaining concerns. So that's the ideal situation where the Commission says, no, this is not. And Microsoft says, all right, fine, we'll do something we won't unbundle. That's what happened with Apple, you may remember. The EU went after Apple, saying, your restriction to developers from saying, you could buy this Kindle book at Amazon.com. They won't let you say that. That's a violation of antitrust. Apple responded by saying, oh, okay, well, we'll allow a third-party store, but we're going to still charge you 27% instead of 30%. And, oh, by the way, there's a 50-cent per user fee, and to which the EU said, no. To which Apple's response was, okay, fine. Well, then you can't have any of the AI stuff that we announced at WWDC. Well, we've heard now from the EU, Apple's decisions not to launch its own artificial intelligence features in the EU. Is that me?
Hell, sorry. No, that was me. Accident.
Man, I was boogieing.
I told you I got a strip tonight, man.
Getting ready for the club. Okay, I get it. Margaret Vestager said on Thursday, it is a stunning declaration of Apple's anti-competitive behavior. She says, this confirms what we've said all along, that Apple is anti-competitive. The short version of the DMA, that is to operate in Europe, companies have to be open for competition, says Vestager. This is a stunning open declaration that Apple already knew 100% that this is a way of disabling competition where they have a stronghold already. She's saying now, the European Competition Commissioner is saying, actually she was formerly Competition Commissioner, now she's just a Commission Vice President. She says, this just proves what we've been saying all along. Now remember, there's a pretty big stick that goes with this. The DMA has fines of 10% of annual global revenue. That'd be over 30 billion euros.
I have a problem with global revenue because that's out of jurisdiction.
I agree, but that's what they do.
Yeah.
It seems very... But, you have to find these guys a lot because, when they give you, a measly $1 billion fine, it's like, well, I'll pay it.
Well, the problem is everyone here is wrong. I mean, I think Apple's position is a little ew, but I'm not going to take the side of the European regulators who's also kind of ew. So there's nobody to root for here. What's kind of weird is
I understand Apple's point of view, but why do you think that there's no merit in what the EU is saying about Apple's store, about NFC, and about the developer fee?
Well, I wouldn't say that there's necessarily no merit in specific complaints that they've got, but they've got a really large regulatory hammer that isn't necessarily well tuned to reality. So do you
think they have standing? I mean,
well, I don't like the 10% global, but they might have standing within their own market.
Within their own market, and that's what Apple's saying.
I don't know if they have something coherent in terms of using you as legal analysis. I'm not entirely sure that everything Apple is trying to do is actually healthy for markets, but I'm not entirely sure the Europeans or even the Americans, for that matter, have any sort of coherent policy answer for why ew is illegal. Right. And I think they should have one if they want to have the regulatory hammer to come and hurt Apple for doing something that's ew.
Right.
So everything is bad, but I don't trust the fixes.
Right.
Well, then there's a thing about the market, though, and I just want to, I want to ask because somebody's smart here. The thing about the market is if you're the dominant person in the market, you get to control the market, so you are, quote unquote, inventing the market. All the other people that have come up and said, well, they did this and they're stopping the market. You know what you could have did? You could have made a similar product before they did, but you didn't. Now you're chasing and you're mad because they're winning. It's like losing and being like, oh, we lost because the other team dominated the game.
Maybe.
Yet that's how it works.
Maybe, but you do get situations where the big tech company didn't necessarily innovate the thing. Somebody was out there pioneering something and then got bought. And so that got the leg up.
So there is a difference between antitrust law in the U.S. and in the EU. And this is, we say this a lot, and I think it's maybe oversimplification, but it is said that in the U.S. they're protecting consumers by making sure that there's competition, and that helps consumers. But in the EU, they're protecting innovation by protecting competitive companies, competing companies like Slack, like Spotify. That EU actions are really designed, and they're often, frankly, precipitated by complaints from other companies. They're designed to protect competition company to company as opposed to protect consumers. I mean, they have the same outcome ultimately, right? Because if you have innovation and competition, the consumers benefit.
Things do flip-flop over the years. I took a class on German law in 2005, and it was just a brief overview of German competition law, and they sort of pointed out that it used to be oriented in one way, and then at some point it just kind of evolved and flip-flopped, and it's gone another way. And
same thing in the U.S.
Same thing.
Actually.
Yeah. I mean, the U.S. is a little... I don't know if we've flip-flopped as opposed to just been really inconsistent, but I think the EU paradigm has flip-flopped in what was the purpose and what they're trying to vindicate.
Under Lena Khan, I think she has said, look, we also want to protect other companies. We don't want monopsonies. We don't want as well as monopolies.
Well, you can always tie most of what they might say for the company terrain to why this would be better for consumers.
In the long run, it's all better for consumers. Yeah. Microsoft says, hey, that AI content, that content on the web, it's okay for our AIs to read them. Now, I wanted to ask you about this, Kathy, because you have defended the right to read. Mm-hmm. Microsoft's CEO of AI, Mustafa Suleyman, says that content put on the web is freeware and can be copied and used to create new content. He was speaking with Andrew Ross Sorkin at the Aspen Ideas Festival this week. He says all content shared on the web is available to be used for AI training unless a content producer says otherwise specifically. Does an AI have the right to read like humans? Certainly, you can argue if you publish something on the web and I read it, unless you put up a paywall or explicitly forbid me, I'm not breaking the law reading it.
He's demonstrating how you can be right and hugely wrong all at the same time. Yes, I think his basic point is correct. I think that that AI, just as a human can read as much as they want on the web, you can deploy software to read on your behalf on the web, and there should not be any sort of legal limitation to doing that. I don't think he's trying to make that pure doctrinal argument. I think he doesn't necessarily understand that pure doctrinal argument, and I think what he also wants is actually to go a little bit farther than that, where he doesn't just want to train his AI, then he also wants the law to let go and let him do stuff with what has been trained. And to some extent, it should, but it's a separate question, separate from the training. So one of the things I've been advocating is right to read should not obstruct the training of AI, but also that when we consider AI and how we're reacting to it, we really need to break it down into its constituent parts and focus very carefully on what is the question, what is going on here, and not let our displeasure with one part of AI use and application change the law with respect to another aspect of
Would it
AI
be
use and application.
sufficient, and I think it is, for a company to say, well, but we will honor your request. If you have a robots.txt that says, do not train on our content, we'll honor that.
I think they could do that.
That would be sufficient.
I think they could. I think there's an argument that you do weaken the final product, that the more language it can consume, the better the product will actually be.
I agree. I think it's in the societal interest that AIs be allowed to train on everything. If they're only trained on public domain content or content that's, bought by the AI, that's not going to be as good.
He's right about what the law lets him do. Antagonizing the public and politicians and courts and stuff like that is really not a good strategy. It's just drawing your lines, digging your heels in and saying, you can't touch me. Somebody will find a way to touch you. It's just, why be obnoxious? It's just making everyone unhappy and out to get you.
As Sean Endicott, who's writing for Windows Central, said, he opened a can of worms.
I mean, just the way he's been go ahead.
Yeah. I was going to say, we're all content creators on here, right? And we all make a living doing this. And the idea that a CEO, CTO of the Microsoft AI group would just come out and say it's all actually free, and we can go take it and go use whatever we want is very counterintuitive to kind of how we have been building business models, right? They can consume all the text I write, they can consume all the videos that you make, Leo, they can consume all the audio. They can provide all the summaries for us. And I think this has been simmering for a while. We don't know what the monetization methodology is going to be. We don't know what kind of the agreements with all of the content creators needs to look like. I'm totally aligned that if you want AI to be good, it should have as much information as possible. But we never set a ground rule or level, even had this discussion about what information should it have access to or not. Right? The robots.txt stuff is a good idea. But if it's already gone through all of my content that I've ever written in ChatGPT 4.0, right? GPT 4.0, do I think in GPT 5, if I have this new robots.txt that says, hey, you may not train on this data, that it's suddenly going to forget all of that? Have we already gone past the point where we can even have this discussion?
Our Twit content is Creative Commons licensed, non-commercial attribution. Is that in effect saying you can't eat all you can eat AI? I mean, I don't care if it does, but
I'm not sure. I know that Creative Commons is heavily thinking about all the implications of this, and also vis-a-vis its own licenses. I don't know if they've reached any conclusions about it, but I know that they're not sleeping on the question.
In effect, we are saying you can use this, but not for commercial purposes. And if it's an AI from a company like Microsoft or Google or OpenAI that plans to make money on this, then that would be, maybe, in my opinion, against our license.
But it might be against your license, but they might not need your license because the right to read would allow it to do the slurping anyway, because the license wouldn't change that. The license really has more to do with the copying than with the consuming. Yeah. And so that's one of the problems one of the things I've been complaining about is everyone's muddling copyright and if you use copyright to complain about this, you're distorting copyright from what it does and makes it bigger than it's actually supposed to be. However, I'm looking at this quote, and I do not like this quote. This quote looks like somebody had a meeting with lawyers and walked away not understanding what they told them, because they use
the AI generative lawyer to come over.
You're talking about
I'm pretty
Microsoft's.
sure they're in litigation and they're getting consulting, and I know there's some really smart lawyers who are in the space and really trying to defend particularly the type of thing that I've been talking about. But to go and sort of, he's talking about a lot more being part of fair use than necessarily is, and anyone can copy it. I'm not necessarily saying right to read affects your ability to copy. And now it may, fair use does apply, but
here's an example. On this Windows Central article, they have a picture from Suleiman's personal website of Suleiman, and they republish it. They say, this is a freeware image that's been reproduced. He said it was okay. Now, obviously, the guy who took the picture might not agree. In this case, it was Suleiman himself. But they're in effect, they're calling his bluff. They're saying, good, we're just going to take stuff from your site then and republish it.
A lot of people have sort of made that argument in reaction to it. And I was looking at social media posts and a little cynical of like, no, they were making a right to read, fair use type argument. People are overreacting. Now I'm looking at his quote and I can see why people are mad.
He says, with respect to content that is already on the open web, the social contract, that's an interesting
I mean,
I never signed it.
The source, where's my social contract of the content since the 90s has been it's fair use. Anyone can copy it, recreate with it, reproduce with it. That has been freeware, if you like. That's been the understanding. Is that the understanding?
I would defend a lot of that, but I do not want to defend him because I don't think he really understands what this is. And
I think, for instance, if you go to my website where I publish writing or my podcasts, obviously I've given you a license to read my writing.
Well, arguably you didn't need to necessarily, but if you published it, you published it.
So that's saying, go ahead, read it.
Yeah.
But it doesn't mean go ahead, copy it and put it under your own name on a website that you charge money for.
But that's more controlled by something traditional, one of the exclusive rights within copyright. Yeah. But arguably the training the AI is just on the reading aspect of it.
So that's interesting. They're not copying it in the sense that they're republishing it, although there is an AI that's in trouble now because people are using it to get around free paywalls and reading content. But assuming it doesn't do that it's chewing it up and mushing it up into its AI brain and doesn't regurgitate word for word what it read from my website, you're saying that's different.
I think the questions would be different. Now, they could potentially be fair use, but you have to look at it more carefully. I don't like this quote because it's just sort of like same thing we were talking about in the Murthy case. You threw too big a wad of provocative stuff at the wall, and you have to be careful. I'm on team nuance. You have to be careful. And he's not making a careful argument. So it's really hard to, I think there's a point where he's talking about a sort of broad ethic of shareability, which I think is important and I would defend. But I think he's trying to make it in a way that is, he's making a defensible argument indefensibly. And I think that's a problem.
Yeah. Summary.ai removes paywalls, ads, and pop-ups from any website. This is their pitch. And they even have a list at the bottom. Hop over these paywalls. Financial Times, Washington Post, CNN, BBC.
I mean, every topic that we've talked about today is just, I want to knock everyone's heads together on both sides of it. You have, these are complicated, difficult issues, and the people advocating on either side of them are terrible. So it's really hard to tease out where is the actual reasonable thing we should think about and be careful about, because it's so easy to hate all the people who are advocating for any of these positions.
At the very least, this was a little tone deaf in this modern world of AI. Let's take a little time out. When we come back, I want to talk to you, Ryan, about I tried to before, but you were muted, about Snapdragon versus Intel. You're watching This Week in Tech. Ryan Shroud is here. Great to have you, as always, Ryan, from signals65.com. Doc Rock from youtube.com/DocRock, and of course Ecamm, and attorney at large. What does that mean as opposed to attorney in my own domain?
I think you're just saying it because it sounds nice.
It does sound good.
I don't think it's actually mapping to anything specific.
Oh, attorney at law. That's what I was trying to say.
Yeah, and even that is sort of old school, whatever. So
it's like a little redundant.
Yeah, none of this is necessary in terms of describing my credential, but go with it if it sounds nice.
I just realized I was thinking attorney at law, and I said attorney at large, which means kind of like you're an attorney for hire, like have law book will travel kind of.
Well, I mean, I'm limited to where I'm licensed and stuff like that, so I wouldn't advertise me that way, but like, you have me as a legal voice.
Yes.
Indiscriminately to talk about whatever legal aspects show up.
Always have you in whenever there's an important Supreme Court case.
Or not.
Or whenever we can.
Yeah.
cgcounsel.com. You're watching This Week in Tech. All right, Ryan Shroud, I'm going to put you on the spot. You used to work for Intel. Do you have any allegiances to Intel?
No, I don't. No, I spent 22 years as an independent technology reviewer, and analyst before I went to work at Intel. Left on good terms, but no, I don't.
You must feel, I certainly do, some sadness because I feel like Intel's kind of lost the thread a little bit.
That's funny what you did.
Get it?
The thread, the hyper thread. Come on, Leo.
Get it? Oh, sorry.
That.
But I feel like they have. Snapdragon. So Qualcomm has in the past said we're better than Intel and failed miserably last year. Terrible. Mm-hmm. But it looks like this time they actually delivered. Yes.
This time it's a much better part. It's like it was interesting having conversations with both Microsoft and Qualcomm in the build up to this release, where they were very adamant that what they wanted to make sure people understood first was that it was a good PC, it was a good computer, before they got into any of this kind of AI Copilot Plus discussion. That's why when you saw Qualcomm start teasing out performance benchmarks and things like that, it was all pretty standard Geekbench, Cinebench type benchmarks that reviewers are used to seeing, that tech enthusiasts are used to paying attention to. And the truth is that the chip that they put together, where those CPU cores were part of that Nuvia acquisition from years ago, that brought over this new Orion CPU core still based on ARM, right? That gives them an automatic boost over anything that they had previously in terms of just pure CPU performance, while still maintaining a lot of that, or almost all of that, kind of performance efficiency that makes the ARM parts so attractive in a lot of ways. Look, I mean, since the release of the Apple M1, I think the writing has been on the wall that things needed to change in the Windows PC ecosystem in order for them to keep up. And it wasn't just about raw benchmarks. It was about, what are you trying to transform the device into? Is it just going to be a laptop that's going to run for 6 hours a day for the rest of your life? Or is it going to be something different, right? Where it's going to run for 2 or 3 days at a time. There's this terminology that somebody at Microsoft mentioned to me, where they say the PC is becoming a sensor for AI, which I really like. It kind of insinuates that this need for it to kind of always be on, always processing, always kind of looking at things. And so with that kind of M1, I kind of look at that as a bending point in the market, right? When Apple released the M1 chip. And the truth is that both Intel and AMD to some degree had been kind of sitting back and doing the same thing for many years. Higher performance, power be damned, right? We'll figure out ways to kind of throttle it where we need to. But if you look at both desktop and notebook parts, the power consumption on those has been getting extreme.
80, 90, 100 watts TPU. I mean, just it's worse than a light bulb.
Yeah. And so I think what's good for everybody with stuff like the Snapdragon X Elite and X Plus processors is that it kind of like sparked everybody. It's kind of woken everybody up. When I was at Intel, I remember very specifically the day that I learned that the next generation of Surface PCs were going to be the consumer variants were going to be based on Qualcomm exclusively and not have Intel in it. Right. And it was kind of like higher up executives have known about it for maybe a few weeks ahead of time, but they were always kind of hoping the decision would get changed. But it kind of woke everybody up and said, hey, this is going to be a real fight that we have to go in.
I think we talked to you at that time, and you said this is going to be good for Intel because it's a wake-up call, and everybody's going to work all the harder.
Yeah, and if you look at Computex last month, no, it's still June, earlier this month, that they announced their Lunar Lake chip, right, which is their next generation part, will be out towards the end of the year, and they're very bullish on performance efficiency and single-threaded power efficiency, that they're going to have the same type of battery life that these laptops that are using the Qualcomm devices, the Qualcomm chips will have. I think they have to prove it because even if you look at things like Meteor Lake and Alder Lake and previous chip platforms before it, they've always made the promise of better power efficiency. It's why they went to big cores and little cores, or P cores and E cores, right? It was this idea, well, this is going to allow us to make more efficient chips. And it didn't really turn into significant differences. Lunar Lake is unique in a couple of ways because the CPU isn't built by Intel. CPU is actually built at TSMC.
Oh, no kidding.
Interesting.
Oh, that's really interesting. On which node?
I don't
4
know if they've
nanometer?
said
No.
specifically. It'll be 4 or 3, right?
Okay.
It'll be.
Interesting.
I think the Qualcomm one is on 4.
Is that an admission?
Apple stuff's on 3.
Is that an admission that Intel never really could get down below 10 nanometers? That maybe we just can't fab it?
I don't see how you could see it any other way, right? That has to be what the takeaway is. They knew what specs they wanted to build for this chip, and they looked at their options and they went with an external foundry instead.
Why couldn't they? I mean, isn't this well known how you do this, or is it something like EUV that they just didn't have access to? I mean, what was TSMC's secret sauce?
TSMC, here's what I think the secret for TSMC is that their biggest customer was Apple.
Yeah.
And so they wanted to make Apple happy. And so they built that process targeting efficiency in smartphones and efficiency and kind of low power designs. Intel had to balance between building super high performance Xeon processors for data centers, desktop parts, and mobile parts. And I still think what Pat Gelsinger, who came in as CEO and kind of revamped the manufacturing side, I think they'll get there.
He wanted to kind of almost create two businesses, a chip design business and a chip fabrication business,
which he's done. In like even now in kind of their business reporting, you'll see the Intel Products division and Intel Foundry division now. Yeah.
What's funny is that he said, as a foundry, we want to make chips for Apple, but it's not. Yeah. They didn't exactly steal TSMC's business.
I mean, that's. I still think it's the right business model for Intel to focus on that, right? With all of the geopolitical stuff happening, as well as kind of just how much more we're going to be requiring from a compute standpoint over the next decade. I think Foundry can be very profitable. But they wanted to be successful in the products business in the interim. And so they made that decision to kind of go external. And that's all because of the pressure that the Snapdragon part really put on them to kind of make that change.
I did not know that they were fabbing them at TSMC. That's actually kind of a shock. They also made some concessions to ARM and to Apple Silicon by adding efficiency cores. They've stopped hyper-threading. Their chips are looking a lot more like Apple Silicon and Qualcomm chips.
It's not a surprise, right? Like they know that they need that power efficiency. I mean,
does that mean they took the wrong path? Intel's done that before. Remember they had Obtanium. What is it? Ultium? I can't remember
You said Obtanium, and now it's
gone. I know it was Unobtainium. It was anyway. It died Itanium because they couldn't really create those chips. They were too hot, too power dependent, And they were fortunate because they had an Israeli kind of skunk works that gave them the core chips.
The the original core.
Yeah.
The
Duo.
The worst branded part. I don't think, like, I look at it as they had very broad goals when they were trying to design chips and manufacturing processes. And you can go all the way back to the days when, they could have won the iPhone chip deal and they decided not to, right? They tried to get back into the mobile smartphone space for a long time, and they just couldn't quite crack that. And they, when you're battling against AMD, it's all about high performance, right? Who's going to get the biggest numbers quicker, right? And when you're battling against Apple, it's a totally different fight. The unfortunate part is that Apple both gets really high performance scores and very efficient use cases out of it too. And that's what we've seen in the first handful of those Copilot Plus PCs that we've seen.
So is it really the advantage is that it's ARM, that it's an ARM architecture? Is that?
It's an interesting religious debate to have.
It's not exactly CISC versus RISC, because I mean, Intel's been doing a lot of RISC stuff, really.
Yeah. I think my guess will be the answer is no. It's not a fundamental difference between ARM and x86, but it is a fundamental difference of where are you focused and what is most important to you on this platform that you're building. Yeah. And Intel seems to think that Lunar Lake is that focus point, and they've got further generations of stuff that are going to come out that are focused on that space that don't have equivalents. Like, these aren't going to be in 65-watt desktops, 150-watt desktops. These chips aren't going to be in data centers, right? And so, in theory, they can build this in a way that's going to meet those goals. And I'll give some credit to Microsoft for sticking to its guns and forcing these kinds of requirements on Intel and AMD. Because it's a pretty big risk to kind of just go out with your new Surface devices and all of your Copilot Plus PC program based solely on a Qualcomm chip that nobody knows, that doesn't have the market share, that doesn't have the mind share that Intel and AMD will have. But the fact that Microsoft said, no, you have to have this NPU performance, you have to have this power efficiency level in order to meet this standard, and they kind of held strong to it, I think is forcing Intel and AMD to maybe do this even in a more aggressive timeline than they would have otherwise.
It's really we're living in a time of change, and this is often the case where the incumbent, the leader for years, because they have such a big legacy market, cannot be as nimble as a newcomer. And in fact, this is the evolution of the technology, and that's not a bad thing. It's a good thing for consumers, but it's got to be tough for Intel. One of the things that people and the media especially is paying a lot of attention to is AI performance, NPUs, neural processing units, and in particular, they've kind of fallen in love with this tera operations per second, or TOPS number. Is that a good number? Is that worth paying any attention to? Because now that's the race. It used to be the megahertz wars. Now it's the TOPS wars.
I think TOPS has probably already come close to wearing out its welcome as a metric of value. What I think is more important,
although Intel is saying we got more TOPS, Lunar Lake's got more TOPS.
And even Microsoft, right, has a 40 TOPS requirement to be qualified to be a Copilot Plus PC, right? So there's some value to it, but what is much more important is what we've started to call kind of like effective TOPS or ETOPS.
Oh God!
And the reason that's it's ETOPS to have another acronym for everybody. But the idea is you can have all the compute power you want in a kind of theoretical best case scenario, but when you apply a specific workload to it, how many operations you're actually getting out of it in real time. It's the same way like in the GPU space. You have flops, teraflops.
Right.
NVIDIA can have a GPU with less teraflops than AMD, but at the end of the day, because of drivers and software implementations and unique feature sets, the NVIDIA GPU will outperform them.
Yeah,
right?
taking just one stat is really not telling you how the ecosystem behaves. And frankly, it's even more than just the processor. It's the speeds of the drives. In fact, one of the things Intel's doing is building the RAM into the die, something Apple pioneered. And you get, Apple calls it unified memory. That seems to be another big speed improvement. Is that so?
Yeah, especially with kind of emerging workloads like AI, the access to memory speed becomes significantly more important. So this on-package memory that Intel has with its Lunar Lake project, or Lunar Lake parts that'll be out later this year, adds a lot of performance. It also adds a lot of efficiency because now that memory is a little bit closer to the compute silicon, so it doesn't have to use as much power to move things around.
Apple users have, for a long time, not expected to be able to upgrade memory, but that's different though in the PC world. They expect to be able to add memory. You can't with this.
No. And it's also interesting when you think about it, because Mac, you always have like 3 processor options, right? Like you don't have a ton of SKUs to choose from. Intel in its market is used to lots, 10, 20, 15 different kind of processor SKUs. Now memory capacity will be one of the primary determining factors of what SKU CPU you pick, because you can't, even an OEM can't just like go in and I want to make a 64 gig version of this laptop or something like that. They won't be able to do that. It'll have to come from Intel all as one device.
How interesting.
Do the manufacturers like that? Are they losing capacity to design their own products tailored to the markets as they understand them? Because now it's the my way or the highway.
There's less differentiation. Yeah.
That's exactly right.
And again, the market has slightly changed, because one of the biggest challenges in the very beginning of going to M processors was explaining to people that, yes, you're going to buy a machine with only 8, RAM in it versus 16, but it will absolutely run our program. I deal with this all the time with, customer support, right? It's like, are you sure it's going to run on 8 gigs? Absolutely. But you're doing like 4K streaming. Understand, it's not the 8 gigs your daddy grew up with. This is different. And I've held entire conferences with 3,000 people on a call on an 8 gig Mac Mini running Ecamm and Zoom, and then I'll pull Final Cut open in the middle of it, and they're like, "Wait, that's like the weakest machine."
I got to point out, even Apple is no longer going to offer 8 gig machines.
No,
because by the way, that's because of AI. So That's because of AI, which needs a lot of RAM, right? Even the phones 100%. Now are going to start at 16.
Are these chips engineered in a way where you can't just mount them on a motherboard, and the motherboard itself has more capacity to install more RAM that you could then? No.
The RAM is in the chip.
Yeah, no.
Well, I could see some RAM, but you can't have additional RAM.
No, that's it.
That's all it can process.
Well, that's where you're going to lose speed too, when you have to leave from the chip to run across a bus to talk to a memory bank and then come back. That has always somewhat been the bottleneck. And, really strange back in the days of being a genius, people would come in all the time, and I was like, I bought.
He was an
RAM
Apple genius, by the way. Just should make that clear.
I think I classify us both as captains. But people would buy this RAM off of like Amazon, and they would come in and swear that it was us, and I was like, no, our machines are just very picky, because the RAM has to be very, very fast, and it has to be a match set. Yeah. If any one person in that is slow, kind of like my brother-in-law, it breaks everything. And that was always the fight with people, is like, well, no, Apple just wants you to buy their RAM. And I was like, no, they're match set. An indie driver can't go get his tires from Goodyear. They are not a match set. It will kill him. Like it has to be.
Although it is still DDR5, isn't it? Or LPDDR5 in these. Yeah. It's the same. It's just it's on die.
So what's the other implication? What else in the ecosystem does this now change, where you've got this embedding and you can't get away from the embedding? Does this change anybody involved with the motherboard production? Does this change if the manufacturers aren't happy?
Keep in mind, this is laptops only.
Laptops,
yeah. Right. So you were never able to kind of have that much flexibility in the laptop space. And if you're building a desktop machine, it's still a socketed processor, slots and socketed memory.
How long is that going to survive, though? Do you think people really want that kind of upgradability, or?
I think there will always be a segment that does, just like there's always a segment of people that want to work on their car and they want to do things like that. I do think it continues to be a smaller and smaller segment, especially as now it used to be the desktop parts always had the leading capabilities and features. Now, in the last couple of generations, we've seen the notebook parts have had kind of the leading edge features, the NPUs, the AI acceleration, the highest performance integrated graphics have all come on these notebook chips.
Isn't that interesting?
What does this do?
Pretty soon, Computer Shopper would be a 9x6 postcard.
What does this do also vis-a-vis the right of repair? Because that's an entire community and an ethos that is, well, if something breaks, I can fix it. And the more you embed, kind of almost getting back to our tying discussion, the more you embed and you can't make some of the functionality separable, you have impacts. I mean, you actually do have a tying effect on the market here in the hardware instead of the software. But if your computer goes kablooey, can you fix your computer? Because now it's one chip to rule it all. And also, aren't there some makers that really sort of have a market based on the modularity?
So, yes, I think there are some implications there, but I think most people probably drastically overestimate on new laptops already in market today what you can fix or repair or upgrade, right? The vast majority of laptops that you're buying today have soldered down memory. So they might be on the motherboard, but it's soldered to the motherboard.
Oh, yes, but that's what the right to repair advocates are not happy with and are trying to have some regulation help pry away. And so there's a lot of
this is where regulation should not get involved.
Regulatory momentum is now going in the direction of, wait a minute, maybe soldering it down is not a thing that we should just turn a blind eye to. So the right of repair people
but
are
the
sort
disadvantage,
of...
Sorry.
No,
the disadvantage comes from speed, right? If the reason why things have to be soldered down or whatever is to get the performance necessary to do the things that we want to do. Even as the chat is sort of sidewinding over here talking about games, I want to play Genshin Impact at the fastest speed possible. I need a machine with this kind of chip with everything soldered down so that it can go at the speed it needs to go. A rocket ship can't get parts from NASA. It needs to be very particular for the performance. And that's the catch-22.
And there are areas where government regulation really should not intrude. Government shouldn't tell a doctor what healthcare decisions its patients should be making, nor should they tell manufacturers how to make their PCs. The market needs to decide. I agree that there's a right to repair, but if the market says we want this kind of performance and this kind of balanced power use.
Well, the market has been upset because the market has wanted to repair and is being told, no, you can't repair, not based on the physical not because of the physical design and having legitimate reasons for the physical design, but somewhat gratuitous ones.
This is not gratuitous. Okay. This is legitimate. Yeah. Actually, Daniel Rubino, who's just on a couple of weeks ago, calls it the Great PC Reset. I mean, we're really seeing a whole new way of thinking about it.
I love that Computer Shopper comment. That really sort of boils it down to
Actually, I hate to tell you, it's not even a postcard anymore. It's just...
Yeah, but it was just, remember, we lived for that gigantic
that thing was huge.
Yeah.
You could make furniture out of it. Yeah.
It really drove home the point, which I guess is the overall point.
But it hasn't been a magazine in quite a long while.
Long time, yeah.
Let alone a postcard. I think I don't even know, is it still a website?
It's a tweet. It's a tweet now. You can get it into 180 characters.
It's a tweet.
I have a very weird analysis to this, but it kind of makes sense. Like, we have been just going to the store and buying bread forever, but the pandemic brought back out the artisanal sourdough people.
Sourdough, baby.
That was going psycho making sourdough all the time. But once everybody got back to work, that kind of just fizzled out.
I threw out my starter a few months ago.
Really?
my COVID
I really
starter,
do understand the right to repair people. Like, I came from that. But once you get to the cool things that having some of this stuff bolted in does, I don't know if I would trade the performance that I'm getting right now out of this M4 iPad for the ability to open it up.
Let's ask our performance guy, though. I don't think you get any performance benefit from surface mounting RAM or surface mounting storage.
No, you do.
You do?
No,
okay.
you can. Yeah. I mean, the whole reason you bring those memory chips on package is
that I
lower
understand.
power, higher
Unified
performance.
memory, I understand. Yeah.
Well, think of unified memory as a software decision. Unified memory basically means the GPU and the CPU share the same pool. They make software decisions based on it. What I'm talking about is how the memory is kind of physically installed into the system on package, just basically meaning, one piece of substrate.
It's a big SoC, a big system on a chip with everything.
Yeah. And even soldering it down on kind of, not on package allows you to get the memory in closer.
Oh, okay.
It allows you to remove an extra PCB, right, as part of a SODIMM or something. It also allows you to do other things like make it thinner, make it more dense, so you can have extra battery, so you can have bigger screens. Like there's other benefits that come to it. Yeah.
So have you tested any of these new Snapdragon Elite PCs?
Yeah, I've looked at the Surface device, both the tablet and the laptop. We've looked at the HP, the Lenovo, the Samsung. We've looked at a lot of them.
And do they live up to the hype, the Qualcomm hype?
I think they do, right? I think the performance is very, very good. I think if Qualcomm did anything wrong in its launch, it was that everybody wants to do. They talked about the absolute highest performance benchmark numbers you're going to get, and the reality is that when you started to get the notebooks out into the real world, they weren't using the top end SKU. A lot of them are using like one step down or two step down, the 80 SKU or the 78 SKU if you want to look those up. But the performance numbers are there. The battery life is absolutely there. The performance efficiency is there. This is something I think, Leo, you and I might have talked about like forever ago. This unsexy benefit of being able to close your laptop and come back in 3 days, and it's drained like 5%.
It's still there, and not only that, but it's instant on, right? You don't have to wait for it to wake up; it's there.
Yeah.
So Paul Ferranda's talked about that. These do
noticed about it immediately. Yeah.
Now, one thing that's missing is GPUs, and this is Apple suffered a little bit as well with this Apple Silicon. They no longer support NVIDIA or Radeon cards. That you're relying on Apple for the GPU, and that's the same for Snapdragon. In fact, PC World says don't buy a Snapdragon X Elite laptop for gaming. It doesn't even compete well against Intel's Arc graphics.
Yeah.
Is that your experience?
I would say yes. If you're looking at PC gaming, this should not be the top option on your list. It has a capable GPU, meaning that it is. We were talking about TOPS before, right? If you look at teraflops as a rating, floating point operations per second, GPUs, that's kind of like the generic number that they throw out in the world. The GPU on the Snapdragon part is actually very strong. Where it is behind everybody else in the market that's been doing this for decades, like Intel and AMD, is software. The drivers aren't as robust. The game compatibility isn't as significant. And so those are the things that stand out to me. You can go find 5 games that run really well. They're going to play great. You can find 5 games that run really poorly, and you can probably find 5 games that won't run at all. Right, if you just kind of take a random sampling, and so that's the hurdle they have to get past. Some of the things like Fortnite, as an example, won't run at all, and that is not because of the GPU. It is because of the anti-cheat software implementation.
Oh my God!
That Epic uses.
How frustrating is that?
These anti-cheats are very, very low-level pieces of software. They're kernel-level things, and so they have to be rewritten for each architecture, and they just haven't done that yet.
Wow. So that'll happen. Game. That'll come. I notice Apple is now pitching itself as a gaming platform because they wrote Metal. They wrote a low-level API for the GPU, and now they're starting to get the performance. So it really is not so much that these hardware devices. I mean, you're getting 3.8 to 4.6 teraflops on the Snapdragon Elite X.
Yep.
That's good performance. It's just the software hasn't caught up, but it will.
Yes.
Does DirectX runs on it, right?
Mm-hmm. Yeah, okay. Absolutely. Yeah. OpenGL, Vulkan, all that stuff is supported on it. Okay. It's just a matter of honestly, Intel went through the same thing when they launched Arc discrete graphics. Right. It was not a muscle that they knew how to exercise. It took a good, I mean, I was in it, right? It took us a good 12 months of software releases to get to a point where Intel Arc as a product was a competitive solution. And I don't think it'll take that long with Qualcomm, if only because they have Microsoft kind of as their primary partner and kind of leaning in to help. But we'll see. That's kind of the open that they need to solve.
Signal 65 has also benchmarked battery life. In fact, you have a long tweet here with graphics as well.
Oh, yeah.
Tell me, good?
It's really good. I mean, if you look at that chart, this is a simple kind of like web browsing.
So the blue line is the HP OmniBook X, and the orange line is the Acer Swift. So this is Core Ultra. This is Snapdragon X Elite.
Yep. And they're both, I
mean, 8 hours ain't bad. The Swift is getting 8 hours. That is not bad.
Yeah. It's not bad. But it gets like 16 and a half,
16 hours for the for the
and this,
OmniBook.
Again, this isn't like offline video playback, which everybody loves to use as a battery metric. I totally get it. But this is kind of like, hey, we open up 20 tabs and we scroll through things and we play a YouTube video for a little while.
This is more realistic. Yeah.
And so far in all of our testing, all the Snapdragon machines have performed very well in that test, right? And that's the hurdle that the other Windows devices from Intel and AMD now have to struggle with. Right?
This is remarkable.
So
double the battery life. Now you might argue, hey, 8 hours is enough for any human, but if you're flying from here to Sydney, you might want that 16 hours battery life. That's pretty amazing.
I'm going on a plane tomorrow, and it's 13 hours.
Yikes.
I'm in the air. Actually in the air is about 12, and then if you count the hour and a half to 2 hours before, I got to go to Boston to go to Atlanta because there's no direct flight to Atlanta from here. And there is, but I don't fly Delta.
And we should say Doc's in Honolulu. He's in Hawaii, so that's a long one.
So all these people with their flight times, I'm like, man, y'all just mad because I don't got no snow. I don't have any flights. I have 0 flights under like 6 hours.
I don't care. It's worth it to be in Hawaii. I can just tell you, it's worth it.
100%.
Yeah, absolutely, absolutely. You're watching this week.
I'm actually more impressed, Ryan, by the thermals. By the way, I saw your other tweet about the thermals. That's pretty impressive.
Tell us about that.
I think that
that's closely related to battery life, really, right?
Yeah. I mean, so what we did was we used a thermal imaging camera to take some stills of all the machines kind of running in different performance modes, and you get a sense of what you're really looking at is kind of like a surface temperature. I'm pointing at my laptop, you can't see it. You're looking at the surface temperature.
Oh, it looks hot.
The laptop,
that's hot,
right? And what's interesting is that in a couple of instances, the Intel machine might have been cooler than the Snapdragon machine.
Wow.
But it was quite a bit louder, right? Because the MSI machine that I think we were using at the time for that testing decided that, hey, we needed to spin up the fans to expel the heat, right? And it all comes as part of that. Yeah, images like this, right?
This is a FLIR image, so this is really cool. This is an infrared picture of where the heat is, and the redder it is, the hotter it is, or the yellower.
The one on the right, the yellower, and it would get even hotter and turn into white. Okay. But yeah, you can see the top, the 37.4 Celsius on the machine on the left is the hot spot that it sees, and then 44.1.
That's a big difference.
On the one on
and
the
these
right.
are both Surface
It is
laptops.
a big difference.
That's huge.
Yeah.
40 is hot.
Yeah.
Yeah, and nobody wants sweaty hands when they're trying to type on me.
And it ties directly to I think to performance.
I keep it in my lap.
Yeah, you're sitting there with your. If you lived in Minnesota, maybe you might not mind it so much, but in Hawaii, it's just too hot. It's so nice to have you, Ryan. I appreciate it. President and GM, Signal 65. We're going to take a quick break. We'll be back with a couple of final stories as we continue with this week in tech. We did say we would talk about the Internet Archive, and so Kathy, I do want to make sure we cover that. I am, as you know, a big fan of the Internet Archive. I support them financially. They're the people who do a lot. I mean, besides storing our entire cultural history for the last 20, 30 years, they also have the what is that? The name of the time machine that lets
Wayback Machine.
The Wayback Machine lets you go back and look at incriminating websites from my youth, things like that.
Anything. Like our world needs an archive, or else we lose touch with our history.
So they got in a little bit of trouble because during COVID, they created what's called an emergency library. They've always been scanning books, but they made a lending library of books that they hadn't bought the e-book rights to. Is that basically it?
They've had the library they've had for ages.
Right.
But at the beginning of COVID, they adapted a key attribute of the library to respond to the emergency of the time, and it changed it a little bit. But basically what they do is libraries have books. If you have the physical book, you can hand it to somebody and they can walk away and read it.
Right. But they have a limited number of books, and you have a limited amount of time to have
so you can't lend. The way they developed the original library uses something called controlled digital lending. And controlled digital lending is for every copy of the physical book, instead of handing somebody the physical copy, you've handed them the electronic copy. You've only handed them you can't hand more electronic copies than you've actually got physical books. It ties up the loan.
And this is what Libby is, and there's a number of programs that libraries in the United States use for digital lending. Libby's is probably the most common one.
I'm not sure if they use the same one, because one of the issues...
I'm saying the Internet Archive does not, but libraries do. And that really... And the publishers... Cory Doctorow has said many times, if the publishers had their way, there would be no libraries at all. You'd have to buy every book. But they acknowledge that libraries exist, and okay, so fine, you're going to lend the books out.
A couple of key things. First of all, the way that the Internet Archive made its library was scanning its books. It made its own electronic copy. The publishers do not like this. They think that unto itself is a violation of their copyrights, but I think the answer is no. And then once they have those copies, then instead of lending the physical, they will lend the electronic, and they can't lend more electronic copies than they have the physical. But this means that instead of the person it means you can have more readers, because you're not limited to readers who can physically get to the library to take the book off the shelf. You can have your readers everywhere. So that's the basic functionality of controlled digital lending. We made an electronic version of it because we're just fulfilling our library purpose, which is to get books into readers' hands. They borrow them, they give them back, and we can't loan out more than what we have.
It's a compromise they had with the publishers to make everybody happy.
Well, it wasn't an official compromise. It's just the publishers left them alone.
Okay.
But then
that's interesting.
Yeah. Then when the pandemic happened, they altered it to the National Emergency Library, I think they were calling it, and they took off the limits. So it no longer was limited to how many physical copies they had, because now all of a sudden nobody had books and everybody needed books, and the only way to put hands in the books of people who needed it, including like kids and students, was to basically just let them check it out.
Libraries
and we'll sort this out.
You couldn't go to the library to get a book.
So the fair use analysis for that is unique to those particular circumstances, because this was the National Emergency Library, and fair use is attached to the First Amendment, which has the right to read, and the point is we're creating all this stuff so it can benefit people. And it was a very limited program, whereas things started to ease, they turned off the National Emergency Library. But that seems to have poked the bear, because after the bear got poked, then it sued not just over the National Emergency Library and whether that was fair use, but the publishers decided to complain that the entire program with controlled digital lending was not fair use. So there was a disappointing decision at the district court where the court got very confused and agreed with the publishers. So this is on appeal. And oral argument was, I believe, on Friday, and I hope it goes well. It was argued by my friend Joe Gratz, and he's an excellent advocate. But this is copyright is complex and messy, and I am worried that the judges who were listening to him may be confused, because a lot of them, there were some questions that did not seem to understand that this was limited, that this was, the principle is if you bought the book, you could lend the book. So why are you limited to only lending the physical book? Why can't you lend an electronic version of the book? And there's prior fair use cases that say you can transform to take the physical and make it electronic. And there was
But if I only buy one copy of 50 Shades of Grey and I lend it out 1,000 times, I could see how the publishers might say, well, you're eating.
Yeah, but you can do that as a library. You can have one copy.
No, they have to buy a copy for each time they lend it out. There's limits on how many they can lend out. They have to have a copy for each time, even digital ones, right?
No, I mean, if you've got a physical book in your library shelf, you can have 1,000 readers. They just have to check it out one at a time.
Oh, well, no, I'm saying 1,000 at a time, at the same time.
Okay, so if you want to lend 1,000 at a time, you do need 1,000 copies, and nothing the Internet Archive has claimed other than during the period of national emergency.
But they scanned one copy of Cinquante Nuances de Grey, and they were lending it out 1 million times.
No, only during the National Emergency Library.
Now they have
before
a limit
and
on,
since.
Yeah.
For the most time of their library, it was one copy. You couldn't have 1,000 copies lent out at a time if you only had one book. That is the basic. They are being sued because they were doing it one for one. During a couple-month period in the National Emergency Library, you could have, in theory, had 1,000 people with one book. But that was limited and just during the pandemic.
Yeah.
Otherwise, what the publishers seem to be arguing is that, and I think this is a very confused way of looking at copyright, is that there is a separate market for being able to sell an ebook, and they think that the copyright analysis, the fair use analysis, is that by lending an electronic version rather than the physical version, but still one for one, still connected to the single copy that the library purchased, that somehow they are competing in the ebook market, and that because they are now competing in the ebook market, even though they didn't buy an ebook, that this is somehow copyright infringement. And this is a really distorted way of interpreting copyright law.
This copy of Elvis Presley's Greatest Movies, Stories, and Photos, it says 25 cents on the front. They obviously bought this at a used bookstore for 25 cents.
No, they may have scanned it from a contributing library.
Oh, okay. So, or a library.
Yeah.
Although, usually libraries don't leave the 25 cent mark on the cover.
It depends.
Anyway, they got it somehow. Yeah. You're saying that I can only one at a time can borrow this, that I can't borrow, that if they only have one copy of this.
If it's already checked out, you go on a waiting list.
And so they're acting just like a regular library.
Exactly. Yes.
Well, what are they in trouble for?
They're in trouble because this changes the paradigm. They have self-created an electronic version of the copy they own.
They never bought the electronic version.
They never bought the electronic version.
Had they bought the electronic version, this would be okay?
Well, I'm sure the publishers would have complained in some other form.
Well, this is getting back to what Corey said from the very beginning, which is publishers are going to look for any way to shut down libraries. They don't like libraries.
So then there was some parts in the argument.
But this seems like not an unreasonable behavior.
I don't think it sounds unreasonable. The library
should they have given the 25 cents to the publisher?
They already did. They bought. What kept getting dropped from the argument is that every loan was predicated off of a purchase they had made. I did not like at the end that a judge dropped the word piracy, and that's irrelevant.
It's not. These are not pirated.
It's purchased, not pirated. So you don't lend anything you haven't bought. And that's a fundamental principle behind controlled digital lending. If you want to lend 2 at a time, you have bought 2 copies. You have bought 2 copies, and the publishers are just being extremely precious about what form you bought the copy in.
So what did Deke do? Well, I'll tell you. He did the only thing a man could do. He grabbed her and he kissed her, but good. By the way, reading from the official copy that I have borrowed from Internet Archive of what turns out to be more like a romance, Elvis Presley's Greatest Movies, Stories, and Photos with colored pinups.
Now you have to check it back in because nobody else can check it out until you.
I can keep this till 5:41 p.m.
Oh, you've done one of the short-term ones, but if you wanted to take it home, you could do it for two weeks. You just have to log in and check it out.
And by the way, they even have a link that says "Purchase this book."
So that's the publishers don't like that either because they think, oh, you're making money, you've turned this into a whole commercial enterprise, but it's just spinning off to.
But you're buying it legitimately.
Yeah, and there's not a ton of money. That's
by the way, they're asking $6.86 for this book, which was only a quarter just a minute ago. I don't know.
That one hasn't been defaced with the 25
you're right.
Sharpie marker on the cover.
I mean, you still have first sale. The libraries are also protected by statute that addresses it, and then the courts were kind of tying themselves
really
into.
that the Internet Archive is not a library?
They assert that they are a library.
I think they are. That says it on the front page.
Yeah. If you're performing library functions, then you're also...
They say digital library. Thank you, Brewster Kale, and I am very happy to be a paying patron because I think the Internet Archive is doing a very important job. And I hope the courts see the light on this.
The publishers at one point, I wasn't paying as much attention to the publishers' argument, but because this was also happening during Supreme Court decision issuing time, and they were talking about how the amici, and I was an amicus in this case, and they're like, the amici keep talking about the public interest, but this isn't about the public interest.
Yes,
this is
it is
about how copyright is supposed to provide incentives for the betterment of society. And I'm like, by her own statement, it was about the public interest. The public interest is you only have copyright up to and because of its ability to serve the public interest. So all of a sudden, if you've interpreted in a way that hurts the public interest, you have done this wrong.
As Corey has always said, the problem with copyright is the only people who really make any money from it are the big companies who take advantage of the copyrights. Here's a final story, and it's all because of the Internet Archive. You ever borrow a DVD from Redbox?
No.
Sure.
You have, yeah?
Yeah.
Redbox was purchased, you may remember, by a company weirdly named Chicken Soup for the Soul Entertainment just a few years ago. Okay. Chicken Soup for the Soul Entertainment has stopped paying its employees. It owes money, according to The Verge, according to the Yanko Rankers, to almost everyone in Hollywood. That's a lot of people. And they are now filing for bankruptcy. Debtor in possession. They're looking for a debtor in possession loan. In other words, a loan to get them off the hook with employees and all the people they owe money to. As Yanko points out, it seems unlikely that they're going to get that loan.
I definitely didn't know that they were still around, though.
That's part of the problem.
Yeah, me neither.
If you honestly,
you said, had I ever borrowed one? Absolutely, I had. You're on vacation.
Sure.
It's raining out. You take the kids out to the grocery store and we pick out a movie or something like that. But yeah, I didn't know they were.
Chicken
I think
Soup
I
took
borrowed
on
once because I just wanted to use the machine.
Yeah, it's cool. It was a limited selection, but and if actually, bodegas, smaller supermarkets all over the country have red boxes. There's plenty of places in Petaluma. There's no movie rental stores anymore, but there are red boxes in plenty of places in Petaluma. Chicken Soup took on $325 million in debt in 2022 to acquire Redbox. It has been sued over a dozen times over unpaid bills. 900, altogether, Chicken Soup says it has $970 million in debt. If anybody would like to lend them that money, I hear DVD rentals are going to be huge in the near future. It seems like this is probably the end of the line for Redbox.
Well, if the streaming services keep jacking up their prices, maybe this makes sense.
Maybe they'll be back.
Yeah.
Right? Yeah.
Yeah.
And they're not competing with Netflix anymore because Netflix gave up that part of the business.
I don't want to end on a sad note, but I guess that's where we are.
Welcome to This Week in Tech.
I'm trying to find something happy, but there's nothing. There's nothing. Just more bad news all around. Thank you, Kathy, for bringing the
bad news.
Bringing
we had
the
a good
legal
decision.
Intelligence.
There was one good decision.
There was Murthy.
Yeah.
Don't forget.
Yeah.
We'll always have Murthy.
For the moment.
Kathy Gellis is at cgcounsel.com, cgcounsel.com. That's the Old English spelling, is it? No. That's what you call a counselor.
Yes.
Yes.
As opposed to COUNCIL, which is something
to a school
else.
counselor, which Kathy is not, which is probably a good thing. She is an attorney. She also writes for the Copia Institute, those briefs, those amici briefs, and writes at Tech Dirt as well. Thank you so much for being here, Kathy. I appreciate it. At Kathy Gellis with a C on Mastodon. Thank you, Dr. Rockter. It's so good to see you, my friend. Have a safe trip.
This is great.
Travel well. Director of Strategic. Are you doing this for Ecamm or for fun?
A little bit of both. I'm going to go speak at a podcasting conference to just basically show people how easy it is to do podcasts using us. And yeah.
Well, I hear
Atlanta, they got good food.
I hear there's a big podcast network. One of the biggest And the oldest that is going to be using Ecamm to do its podcasts real soon.
Yes. Actually, I can't wait to. I told Russell to get back to me and tell me like all the inner secret sauce, because I think his ideas are incredible right now.
Good,
they're really good.
So you guys are you're jibing.
Oh yeah, I told him give me an excuse to fly out there so I can have to fix stuff, but don't tell Katie. I'm just coming to hang with you.
Yeah. No, we'll give you an excuse. Yeah, we desperately need you to help us set up. Doc, it's always great to talk to you. Safe travels and have fun in Atlanta.
Mahalo, brother.
Yep. Mahalo aloha, as they say on Hawaiian Airlines. Not HawaiianAirlinesFans.com. That's a different Hawaiian Airlines. Thank you, Ryan Shrout. So great to see you again, longtime host of This Week in Computer Hardware. You were always my hardware guru, and it's really fun to have that chat with you again. It's been too long, but come back soon.
Anytime. Love to be here. It's great. CEO, president, and general manager at Signal65.com. Did I get all the titles in? It's fine. Yeah, all of those. That's when they asked me, I said, just put Signal65.com at the end.
That's all we need. Fine. He's the boss. Yeah. He's the guy. He's the man. So great to see you. Thanks to all of you. Thanks also to our Club Twit members who make this show possible. As you probably noticed, ad support for podcasting in general, and this one specifically, dwindling, but we want to keep working. We want to keep helping you understand technology, keep entertaining you, keeping you company. If you like what we do and you want to support it, the best way to do that is to join the club. Now, we try to make this affordable. It's $7 a month. Just for $7 a month, you get ad-free versions of all the shows. You get access to the Discord and that great community of Club Twit members. They're wonderful. You also get special events like Stacy's Book Club, Creative Corner with Micah Sargent. You get video for all the shows we do audio only, like Hands on Macintosh, Hands on Windows. Micah does Hands on Macintosh. Paul Thurrott does Hands on Windows, the Untitled Linux Show. Home Theater Geeks with Scott Wilkinson, and on and on and on. We love what we do, and we think it's an important service, but unfortunately, we're going to have to come to you for help. Please join the club. You can start at $7 a month. If you feel generous, you can pay more. You don't have to. Just go to twit.tv/clubtwit to learn more, and thank you in advance for your support. We really appreciate it. We do this show every Sunday, 2 to 5 p.m. Pacific. That's 5 to 8 p.m. Eastern. That is 2100 UTC. You can watch us do it live at youtube.com/twit/live. Soon, by the way, thanks to Ecamm, we're going to be on, I believe, we're going to be on more platforms, and that'll be nice. But right now, that's where we live. After the fact, on-demand versions of the show available at the website, of course, always, twit.tv. There is a dedicated YouTube channel for the episodes of This Week in Tech. That's a great place to go if you want to share a clip. You want to say, hey, did you know that Doc Rock was a male stripper? You could just share that clip with all your friends and family. No, he wasn't. He just spins the discs. Now I lost my thread. Oh, you can also subscribe. That's the best thing to do. Subscribe. That way you get Twit automatically the minute we've got it all produced. Benito finishes it up, and then you can get a copy. And you'll have it in time for your Monday morning commute. We really appreciate your being here. Thank you for joining us, and we will see you next time. As I've been saying now for we're now in our 20th year. Another Twit is in the can. Bye-bye.